I'm gonna go. Good afternoon, everyone. And let's see here. Jeremy, can you just confirm? It looks like everybody is getting into the, the Zoom meeting now. I'll just give a quick second and we will get started. All right, everyone. Welcome to the 2025 Advanced Real Property Certification Academy. I hope that's what everyone is here for. If not, you're in for a fun time and some good discussion. So today, we have a great presentation for you and to look at our agenda. Today, we're going to go through some quick introductions. We're going to talk about who your presenters are, who your presenters are not. We'll go through the bios for your presenters, and then we're going to look at the study guide materials. After that, we're going to jump into the heart of our presentation today, which is the sample essay questions. So the homestead presentation will be by Stephanie Emrick. The real estate transactions will be presented by Caleb Hinton, and then ethics will be presented by Cynthia Raleigh. And you can see a general outline of time that we'll be spending on each of those questions. Now, our presentation today, we let you all know that it would be from 12 to 3 o'clock today, and we wanted to be respectful of your time as we did this. However, there will be times the presenters will be still online from 3 to 4 today if there are additional questions. In addition, if you'd like to continue discussing the exam with each other and maybe even find some potential study buddies, we'd love for you to share that time with us after 3 and continue discussing the upcoming exam. So this workshop, this academy, is an interactive process. So we welcome your questions and your participation. And so please know that we do need you to interact with us as we go through this. As a reminder, our time is tight today since we are reviewing 3 essay questions. So if there is a question that is not relevant to the exam or may take more time than we really have today, we may postpone that answer or that conversation until after 3 o'clock today or to another day. But we do very much so care about your questions. So moving on to who we are, who your presenters are. We are a group of Florida Bar board certified real estate lawyers who volunteered to help others going through the process. So we have gone through the rigorous process of studying. We've taken the exam and passed, and now we want to give back and hopefully help you on your journey as well. As far as who we are not, to clarify, we did not write the exam, we do not grade the exam, and we do not know what will be on the exam. So turning to our presenters today, Stephanie Emrick is, she lives in Gainesville. There's Stephanie. Thank you, Stephanie. She's a shareholder at Scruggs, Carmichael, and Warshaw. Her practice includes title litigation and complex real estate transactions. She obtained her JD from the University of Florida, Levin College of Law, magna cum laude. Go Gators. While she was in law school, she was the managing editor for the Florida Law Review. Thank you for doing that very hard work. And she was published in both the Florida Law Review and the Maryland Law Review with the topic of transfer on death deeds. Those are some of my favorite types of deeds. She is also a member of the Title Issues and Standards Committee of Reptile, the Florida Land Title Association, and the North Florida Association of Real Estate Attorneys. Next, Caleb Hinton is a senior underwriting counsel for the fund. He obtained both his BS in criminology and his JD from Florida State University. Go Noles. Before the fund, his practice focused on commercial leasing and commercial land transactions, including acquisitions, development, and sales. Next up is Cynthia Raleigh. Cynthia is the commercial underwriting manager at the fund. She lives in Orlando. She obtained her JD from the University of Miami School of Law, go Canes. and she has a BS from New York University. She's a member of Reptile. And prior to the fund, she advised developers, home builders, and individuals nationwide in sales, purchases, and leasing. So Cynthia was also a presenter at the Academy last year, which was our inaugural Academy session, and she's been integral to developing this program. Lloyd Granite is the reason we are here. Lloyd was the inspiration behind this academy, and I am so grateful for his tireless pursuit of helping others achieve board certification. Lloyd lives in Boca Raton with his wife and his 2 daughters. He has been board certified, and I love this, board certified since 2006. He was the 2012-2013 chair of the Real Estate Law Certification Committee. He is the current chair of the Advanced Real Estate Certification Review course. He is the past chair of the Real Estate Leasing Committee, and he is currently a member of the Executive Council of Reptile. He has co-authored an article entitled Drafting and Negotiating Purchase and Sale Contracts for Commercial Properties, which is in the current edition of the Florida Real Property Complex Transactions published by the Florida Bar. But he doesn't stop there. Lloyd is also a certified public accountant and active right now. He maintains an active real estate license, and he's a member of the Realtors Commercial Alliance. He's a frequent lecturer on commercial contracts, and he taught business law at the University of Miami School of Business. And on top of that, he's just a really nice human being that invests in the success of other people. So thank you, Lloyd, for all that you have done for us. My name is Jennifer Fisher. Our firm is a boutique law firm that handles land use and real estate matters. So we walk clients all the way through site identification, zoning, entitlements, closing, government incentives, and development issues. Recently, I've been able to assist clients pursuing community development block grant disaster recovery funding as our area recovers from Hurricane Ian. Now, what I love about real estate law is that no 2 cases are exactly alike because real estate law is a broad practice area. And because real estate law is broad, we make studies for the real estate board exam require a lot of advanced preparation. So with that in mind, let's go ahead and dive in to how we prepare for the exam. But before we do that, we are going to do just a quick survey of our participants. No judgment, but this is going to help our speakers know how much to get into the essay prompts, kind of how quickly to move through the material to make it most beneficial for you. So I've never done this before, but we're going to figure this out. I am going to share a survey. I appreciate your patience with me as I figure out how to do this. Here we go. And I'm going to launch it. All right, thank you everyone for doing this. So as we are calculating, move this back over. All right. And presenters, wow, you guys are doing a great job. This is a mandatory poll, so I believe I need everyone to likewise be answering this. Great. So it looks like at least half of our group has definitely read the sample question. And if I could ask my other presenters, are you able to see the results? Can you give me a thumbs up if you can see the results? Great. Okay, great. So wonderful. Wonderful for the participants to see that you all have prepared well for this today. Thank you so much for that. If you have not had time to do much preparation, no worries. We are glad that you are here today and part of the conversation because just being here today hopefully will be beneficial and will help you as you lead into the exam. So thank you for doing that. I'm going to go ahead and end the poll. All right. So moving along, one of the most pertinent questions, right, is where do I find study materials for this exam? When we were getting ready for the bar, there was Barbary and all these other materials, right? Well, there's nothing official for this particular exam. However, the Florida Bar's website does give us a lot of information on how to help prepare. So, first place to start is the Florida Bar's website, and you can just Google Florida Bar Real Estate Law Certification, and it will get you to this website, or you can kind of on the bar's website follow these particular instructions here. So once you get to that website, you're going to scroll down quite a way through the website and you will get to this exam tools and information. And here there will be different tabs. So exam specifications, study guide, and sample questions. And these are the three tabs we're going to go through today. So first, for the exam specifications, this gives you really important information. So this examination content is very important. This is telling you what to be prepared for. And it says topics that may be covered. I would change that to topics that more than likely really be ready to see on the exam. It's a very long list. And so this is where it goes into preparation is key for doing well on this exam. Now, I want to take your attention down to these last couple paragraphs, and I want to go through these with you. So these exam specifications tell us that the total number of points possible on the exam are 360 points. The final overall score is calculated by totaling the total points scored for the multiple choice and the essays. And then it breaks down those particular points available a little bit more. So there will be 45 multiple choice questions worth 3 points each. There will be one long essay on homestead worth 45 points. One long essay on transactional analysis worth 60 points. And then 6 short essays worth 20 points each, or a total of 120 points. The passing standard for the examination is 70%. So if we do the math, you need 252 points to pass. The homestead question and the transaction analysis question added together gives you a possible point total of 105 points of the 252 points that you need to pass. So that is why we are doing a large focus on that homestead essay question and that transaction analysis question, because those are two things that you can prepare for and you can practice in advance. In addition, the study guide gives an example of an ethics essay prompt. So we're reviewing that example ethics essay prompt as well today. The next thing on that website is a list of potential study guide materials. So remember, for this particular exam, the examinees need to put together their own study guide material. And so we have a list of suggestions. It's not all encompassing, but this is a great start of where to pull those materials. So certification review course, which I know many of you have already done, CLEs from the Florida Bar, CLEs from title underwriters, the uniform title standards. I spent a lot of time there when I was prepping. Underwriter guides, Florida Bar Action Line articles, Florida Bar Journal articles, case law, ethics opinions, Florida statutes, Florida administrative codes, federal statutes and regulations, of course, the Florida Bar rules on professionalism and ethics, settlement statements. I also reviewed title insurance jackets word for word. And then also a great thing to review is the FAR bar contract and other form contracts. And there's certainly more materials you can utilize, but this is a great starting place. The last document that we're going to kind of review together today that's posted on the Florida Bar website is the sample questions. So this is an 11-page document. It consists of 8 multiple choice questions. Today, we don't have time to go through all the multiple choice questions, but the great thing about these sample questions that are posted on the website is they give you the answer to the question. So you can go through all 8 of these, and I highly recommend that you look at all 8 of them and get an idea of how the questions will be presented and which answers are presented as the correct answer. As a reminder on these multiple choice questions, you are not penalized for an incorrect answer. Therefore, it is to your benefit and your advantage to go ahead and answer every single multiple choice question. All right, moving along to what will your testing day look like? So in the morning, you will have a 3-hour session in which you will do 45 multiple choice questions worth 3 points each, and 1 long essay on homestead worth 45 points. So if you are pacing yourself, you'll probably want to spend about 2 hours and 15 minutes on those multiple choice questions. If you're going about 3 minutes per multiple choice question, and probably about 45 minutes on that homestead essay. In the afternoon session, again, it'll be a 3-hour session. You'll have 1 long essay on transaction analysis worth 60 points. And then you'll have 6 short essays worth about 20 points each. So 120 points total for those short essays. Now, remember, the total number of points generally corresponds to the time allocation. So that transaction analysis, if you're pacing, you'll probably want to spend about 60 minutes on that, about an hour, and then about 120 minutes, 2 hours on your short essays. All right. So as a reminder, as we jump into our session today, the example essay responses that we'll be reviewing together were prepared by Florida Bar board certified real estate attorneys. These attorneys have the benefit of unlimited time and access to legal research tools. So when you see these responses, do not be intimidated. Our hope is that these will help you issue spot and study. Remember that the graders of the exam know that you are under time constraints and that you are seeing a brand new fact pattern. So with that said, we are going to go ahead and get on to the main event. So Stephanie, I'm going to go ahead and turn it over to you for homestead issue spotting and essay writing.
Thank you so much, Jennifer. And I just want to thank everybody, especially you, Lloyd, for asking me to be here today. And then to the rest of the group, Jennifer and Cynthia did an amazing job with this last year. I thought that it was extremely helpful to me, not only to hear other people's comments, what they were doing, but really just to prep and hear somebody that had been through the exam. So happy to help, hope that I can. Looking forward to doing it with Caleb next year and passing this along. And I would also say that happy Friday afternoon. So to all of those that are taking the exam this year, you're spending your Friday afternoon talking about certification essay questions, you're probably on the right track and doing what you need to do to get ready for this. So I'm going to go ahead and jump in. It looked like everybody had read the facts, but before I jump into the actual question, I'm going to share with you kind of my personal theory on how I handled the questions for the essay. So because I knew transactions and homestead were specific topics, I made sure that I had kind of a memorized outline in my head of things that I knew that I wanted to talk about, or at least things that I wanted to make sure I considered in going through my analysis, because of course, the day of the exam, you're going to be stressed, you're going to be, under a time crunch. And so I just wanted to make it be kind of rote memory. Like when it's homestead, here are the things that I want to make sure that I talk about and I don't forget. And it was something easy to kind of review going forward. I'm going to share my screen. I believe that they are going to circulate materials later with the answer. You'll be able to see those sample answers. I didn't share this with the materials that will be circulated because I feel like the learning. Okay. Can you see my screen? Okay, can you see the homestead outline? Okay, something just went a little wonky with my Zoom, sorry. But yeah, so looking at this, let me move you over here so I'm actually looking at my screen. Looking at this, I really just wanted to go through some questions. So it's the threshold question of, oh, did I just mess that up? Okay, good. So the threshold question is this property really homestead? Is it their permanent residence?
Wait, Stephanie, for 1 second, before you get on a roll, there's
Yes.
a little feedback coming from your microphone. I don't know if you can get closer to it or what it is. I don't know. Jeremy, if you can assist also, but we're seeing some comments in the chat. There's a little feedback.
Is that any better? I just realized my cover was partially covering the mic.
I think a little, but you guys can keep commenting in the chat and I'll tell Stephanie that if you guys still think it's not okay.
Thank you, Boyd.
Thanks.
I'll try to slow down a little, although that's tough. So anyways, this was my general outline of the things that I wanted to make sure I covered. And I feel relatively confident that in most homestead questions, a good number of these items are going to come up and you should understand, how that's going to operate and how that's going to fit into the facts of your essay. So whatever your fact pattern may be. So whether it's a permanent residence, what does that require? What's the size? Is it going to, what if it's in the city limits? What if it's out of the city limits? Little things that you'll just know to pick up on. So this is kind of my example of how I went through that. And then as you get into the constitutional homestead protections, is there something in the fact pattern for homestead that talks about there being a deed? Did the spouse join? Was it a mortgage? Did the spouse join? If it was a deed without the joinder of the spouse, is that different from if it was a mortgage without the joinder of a spouse? Practice tip, the answer is yes. On the constitutional homestead protection, we all know that that's not subject to devise if the owner is survived by a spouse and a minor child. But for me, I just wanted to make that a little easier. And so I kind of put some questions together. If there's a minor child, automatically not going to be divisable. We go to what happens if it was intestate. If there was a surviving spouse, is it devised to the surviving spouse? If yes, it goes to the surviving spouse. If no, it's not divisible and goes to the intestate owner. So this was kind of how I worked through that. And then the exceptions for the for sale of predators, I think is very important to make sure. I would bet that something in this area would be a part of the fact pattern. And I would guarantee that there will be some judgment lien issue. And so I made a separate outline, which I haven't shared here because it was quite extensive, on different types of judgment liens. And going through this sample, I will tell you, I took this from what I actually prepared in preparation for this exact academy last year on this exact question, but I have expanded on that dramatically since then. So yes, this is not what you should expect to do in 45 minutes, but it was the format that I wrote it. And I will say that I actually wrote all of my essays for every question in this kind of outline form. So we'll talk about that a little bit as we go forward. So I'm going to jump into the question, and I'm just going to read through that so that we can make sure everybody's on the same page. And then after that, we'll jump in and hopefully everybody can participate in giving us some of their ideas and we can talk through some different ideas. So a wife died testate on February 3rd, 2020, and was survived by her 2 adult children from prior marriage, son 1 and son 2, her husband, and a daughter, a minor. Ding, ding, ding. The wife's estate plan gave her only asset, a 100-acre homestead property, to son 1 and specifically excluded her other family members. Son 1 is not the minor child, so we already know there's an issue there. The property is located in Seminole County, outside the city limits of Oviedo, and although titled in the wife's name alone, was the home of her husband and daughter. Her husband and daughter continue to reside on the property. You have learned the following. On June 30th, 2016, the bank obtained a $500,000 judgment against the husband and the wife. Husband and wife failed to maintain the property, and as a result, Seminole County brought a code enforcement case resulting in an order imposing a code enforcement lien. The order was recorded on July 1st, 2019. The wife and a contractor entered into an agreement for the installation of an equestrian training facility on the property. Despite the timely filing of a notice of commencement 11 months ago and the completion of the project, the wife failed to pay the contractor's final invoice, and then as a result, the contractor filed and served a claim of lien for the $102,000 that remains unpaid. Son 1 has an outstanding valid judgment of $10,000, which was recorded in Seminole County 10 years ago in favor of lender 1, and son 2 has an outstanding valid judgment of $200,000, which was recorded in Seminole County 3 years ago in favor of lender 2. Your client, a developer, approaches you for advice on making an offer to purchase the property. The developer expects to receive marketable title and to close as soon as possible. In your response to the developer, please discuss the following. What is the status of the title to the property? What is the status of the various judgments and liens? And what needs to be done to prepare title for closing? Okay, so I would suggest, and everybody does this a little bit differently, but for me, I always want to make sure that I'm going back to the call of the question. So you'll notice that I did not do this in my sample answer that I'm going to share in just a moment, but Jennifer explained this to me last year during this academy. And so I took her practice tip and I'm going to pass it along to you, that I would take the call of the question and I would actually type that as subheadings to your response. And I would put that in your response from the very beginning. When you're going through your essays, it's actually a good idea before you even read the fact pattern to go through the call of the question so that you understand what you're looking for. So as we just read through this, it kind of occurred to me again that I was not thinking about this from a developer's standpoint, but that does give a little bit of a lens that you need to look through the facts. So starting back from the beginning, and I seem to have lost all of my video of everyone else. And also, I don't see my presenter window anymore, but I would like to try to open it up. Oh, Jennifer's back.
Yeah, we're all here. We just muted and turned our, we're still here. You didn't lose us.
Oh, that's okay. I was trying to find my list of attendees. It's gone all of a sudden. Jeremy, are you there? Like, how will I ask people to chime in their thoughts if I can't see them?
They could use the chat if you want to.
And Stephanie, so in your participants list, there's a panelist list and then an attendee list. And if you put your mouse over a particular name, you can allow them to talk.
Somehow I lost that list when I'm screen sharing.
Okay.
Okay, well, we'll figure that out. Oh, wait, here we go. Okay, I've got it back. I apologize, guys. What do we have? Okay, so I'm going to go through. Does anybody have any initial things? Let's go with our facts kind of in line. So the wife died testate on February 3rd and was survived by her 2 adult children from a prior marriage, son 1 and son 2, her husband, and a daughter who's a minor. So first question is going to be a softball so that somebody can jump in and not be worried about what we think. What do we think about the fact that there's a daughter who's a minor? Actually, I guess I don't have a way to know who's raising their hand. So I guess I'm just going to walk through it. I guess we're not going to be interactive. Oh, I see a hand. Okay, David, thank you.
Is this working? Can you hear me?
I can, perfect.
Awesome. Because there's a minor, we know from Kelly's paradigm and the statutes that any device is not effective. So the fact that she has a will really doesn't matter to us as far as how she attempts to devise the property within her will. We know that under the statute, the husband will end up with a life estate and the remainder will go to the lineal descendants equally, which means son 1, son 2, and the minor daughter.
That's right. So we know there's a minor. We know that whatever device is there doesn't matter. And then we move on to what happens and whether it would either be a life estate to the spouse and the remainder to all lineal descendants, or if the spouse elects, then they would get their 50% interest and share tenants in common with the lineal descendants. And so that kind of changes our analysis a little bit as you go through. And so this is something that I would suggest is discussed early on in your paper about how this could go, different ways and whether there was an interest there and what interest, if any, would pass along to the others, especially as we get into son 1 and son 2. And so then we talk about the wife's estate plan has only one asset, a 100-acre property, and it goes to Son One specifically, so we're not worried about that. But it's located in Seminole County outside the city limits of Oviedo and titled in the wife's name alone. And so why does it matter that it's outside the city limits? Cynthia?
We get up to 160 contiguous acres outside a municipality,
Perfect. And what if it was inside?
half an acre.
Perfect. And what about the fact that it's titled in the wife's name alone? Does that matter as to whether it can be homestead?
Well, you've got, if it's in the wife's name alone and it's not, it could have been titled husband and wife, then we wouldn't even be doing the analysis because it'd be tenancy by entireties and would pass outside of probate.
But if it's the husband and wife's homestead and it's just in the wife's name alone, can it still constitute homestead?
Yeah, absolutely.
Absolutely. And I feel like this is something that they maybe throw in. I've seen on a couple of sample questions that it's only in one spouse's name, but that is irrelevant. That's right. Okay, so another interesting point as we get into the next ones, and I don't have a specific question, but it's interesting to note that it says her husband and daughter continue to reside on the property. And so we have Son One and Son Two that might have an interest, but we have to note that they are not residing on the property. And so even though it was the homestead of the wife, it will no longer be the homestead of the wife, obviously after she passes, but it will be the homestead property then of the husband and daughter because they're continuing to reside there, but not of Son One and Son Two. So then you get through each of the judgments. And so let's talk about the first one. On June 30th, 2016, bank obtained a $500,000 judgment against the husband and the wife. Anybody have any thoughts on that one? Cynthia and David, I see your hand. Thank you. Anybody else want to jump in? Okay. David?
Think because this was an actual judgment against the wife, that it doesn't attach to homestead property and that it shouldn't be an issue clearing title for a sale. That's what I think.
Okay. Cynthia, what do you think? Oh, I have some more hands now.
Sorry, gotta unmute.
That's okay.
Well, it's a judgment against husband and wife. Basically it's homestead property, so it wouldn't attach. Obviously, if for some reason they thought it did for title purposes, you could do that notice to homestead. Gives them 45 days, to do, what they think they're going to do as far as the judgment. But since it was homestead, it's not going to attach. And then the other thing is, let's say that the husband elects the 1/2 tenant in common interest, and then you have the other half distributed to all the descendants. Even though, it would still be his home protected homestead, at least that 1/2, if he still resides there.
That's great. Philip, did you want to add something?
Yeah, I went kind of like a direction of it depends on what the judgment was for. Because I wasn't sure if it was some kind of mortgage, like a first position mortgage, if that makes sense. That's kind of what I was thinking. So I was kind of like talking about both in my notes. I didn't do like a full essay on it, but I kind of, that's what I picked up and made some notes on. I don't know if that's relevant.
Well, I think that's exactly right. I mean, it says a judgment, which makes us think that it's not a mortgage, but I think that, I'm not on the grading committee, and so I can't say, but if I were on the grading committee, I would certainly say that that would be, kind of a check in your column if you picked up on that topic and you knew that whether it was a mortgage that had been consensually signed, voluntarily signed by both the husband and wife, then it would attach. So that would be a really good opportunity to talk about that law and just show that you know. And so I think that that's a really good point.
Oh, okay. Thank you.
Yeah, and I think that, so I will just break real quick. I want to go back in talking with some of the people from last year. I do think that it's important to show where, this is kind of going back to law school. As attorneys, we always think that we need to write something and it needs to be the absolute correct answer. And sometimes we hedge against saying something if we're not certain of it, but I think this is the exact opposite. I think you have to write this essay as if you're going back to law school and showing the professor all that you know. And so you need to show the committee what you do know and what would change. And if there's something that maybe you don't know as well, maybe you don't focus as much on that. But for example, this point is, Philip's point is a great point that you could totally launch off into. I understand how it would be different if it was a mortgage or if the husband and wife had consensually signed. Also, something else here that I didn't hear anybody pick up on is it kind of depends what this judgment is for. What if it was for labor to the homestead? That would attach. I mean, there's a specific exception to the protection from creditors. And so just on the face of it, you really want to, on every point, you want to be kind of weighing both sides. Like, here's what I think it is based on what the facts say. But if it happens to be this, or this is what I would need to know, here's how that would change. And so, of course, as lawyers, our answers to many things is it depends. And you have to explain why it depends. And depending on those other facts that you don't know, what would that mean? What would the rule then be that would apply, and how would that apply to the facts? The next one talks about that they failed to maintain the property as a result. Seminole County has put a code enforcement lien on the property, and they talk about when the order was recorded. And you guys might have even more on this. I will tell you, when I first read this, I was not up to speed on whether a code enforcement lien that was specifically on the home, that was the homestead, could attach to the homestead. I think we have since figured out that it does not, but what are you guys have any other thoughts? And did anybody pick up on anything as to these dates? Okay, I'm not seeing any hands, so I'm going to keep moving on. The next one talks about the wife and a contractor who entered into an agreement for the installation of an equestrian training facility on the property. Despite the timely filing of a notice of commencement 11 months ago and the completion of the project, the wife failed to pay the contractor's final invoice, and as a result, the contractor filed and served a claim of lien for the $102,000 that remains unpaid. I see Megan.
Hello?
Hi.
Oh, hi. So I would say that this is a business, so that this would attach to the homestead, and as well as the fact that it looks like it's all timely done. The notice of commencement's there 11 months ago, so it's still outstanding. She didn't pay. This is probably something that would need to be paid, and this would be not characterized as homestead.
I think that's right. I think I agree with that analysis. However, what if this is a very wealthy family and they want to have a private equestrian training facility for just the family members to ride?
Yeah, I don't know. I would maybe think that this may still need to be paid because it's a notice of commencement and they've improved the property.
Right, and I think that's exactly right. I think that you need to talk about the difference of whether it was homestead and why it may still attach. If it was not homestead, we don't really have to go through the analysis. We just have to say, it doesn't qualify for the homestead protection because it was not used as part of the primary residence of the owner. But if in fact it was homestead property, it would still be exempt because it was for a specific improvement to that homestead property. Anybody else want to add anything to that? Okay. So Son 1 has an outstanding valid judgment of $10,000, which was recorded in Seminole County 10 years ago in favor of lender number 1. I'm going to go to Stephen.
Hi, just going back to the previous one, doesn't the claim of lien need to be recorded within 90 days from the last day they furnished labor and materials. So if the notice of commencement was 11 months ago and the project was completed, it doesn't talk about when it was completed. But if the completed project was done around that 11-month time period, wouldn't the claim of lien be untimely?
It could potentially be. Yes, absolutely. And I will be honest, construction law was my weakest area that I spent a lot of time studying for. But since I took the test a year ago, I haven't paid much attention to it. I haven't remembered it since then. But I think that that is correct. And I would say that that's, again, a perfect example of when you could bring that. I also think that some other points you could talk about here is that the notice of commencement is only good for the 1 year. And that if somebody had filed a claim of lien, I think there's also a 1-year limit of how long they can actually bring a suit to enforce that, if I'm correct.
The
So
1 year after.
Yeah, so don't hold me to that, but I think that's true. And I think that all of those construction law timing issues would be excellent discussion points right here. Thank you, Stephen. Okay, so back to son 1 and his outstanding judgment of $10,000 that was recorded 10 years ago. Megan? Megan, did you have something on this one? Okay. Anybody else? Thank you. Cynthia.
I would say you can get into that Knox judgment paradigm, talk about the fact that it's 10 years old. So unless they've filed a new certified copy of the judgment within the time frame, it may no longer be valid as to whatever son 1's interest is. And then that goes back to the question of whether or not the husband elects the tenant in common or keeps the life estate, depending on how quickly, assuming they did recertify it and it is a valid judgment, how quickly they could levy against son 1's interest in the property. Because obviously he doesn't live there, so he doesn't have any homestead creditor protection.
That's exactly right. And I think that that makes a really good point. So this one is really packed, because you really have to, when you get into son 1 and son 2, you really have to refer back to your prior analysis in that there's 2 different ways that they could have taken. They may have taken an interest as tenants in commons, which I believe would be a 1/6 interest, or they may have a 1/3 arrangement interest that would be subject to the husband's life estate. And so I think that what you're looking for here is basically to say, if it went this way, this is what happens. And if it went that way, I think this is what happens. I think the timing of it being 10 years was, how are we past 10 years or just at 10 years, whether certified copy re-recorded, all of those things are really good topics to discuss here. And then what's the difference between whether he has a life estate interest or whether he has a 1/6 interest, and then what happens with that? And so why, when we're looking at this through the lens of our response to the developer as to what is the status of the title of property, I think you have to go through all that analysis. And then I think the answer becomes, but for our purposes, we want to be conservative because we are representing the developer. That's who our client is. And so if we have any question as to whether something's going to attach, I think it's completely prudent to say in your answer, maybe this, maybe that, but the conservative approach to make sure our client is protected is to go ahead and pay this or require that it be paid before moving forward. And then son 2 has an outstanding valid judgment of $200,000. And this was recorded in Seminole County 3 years ago in favor of lender 2. Anybody have thoughts on this one? New one, Olivia.
Okay, I think you're looking at a similar fact pattern to the last scenario. I would say probably the one distinction is still going back to the certification where you're kind of a little further along and not having to get that or you have more time before you have to go get that recertified. And then also with these judgments, you know, was it certified to begin with? Because I don't think either was mentioned. Because that does.
That's a good point. And this is also, you know, there's also some specifics as to the judgment requirements, right? Like, was the proper address of the judgment holder on the face of the judgment? Like, some of those other enforceability issues are certainly something that can be discussed as to both of these. Okay, and so then moving into the questions. When you were to answer your, like, each of the questions, what is the status of the title to real property? I'm going to show you guys the two different answers that I have, which we can go through and see if there was anything else that were on our answers. So the first one. So the one you're looking at here, this is Jennifer's that she provided last year. So walking through this one, you can see that it kind of goes back to some of the same elements that we discussed in the beginning. Is the property homestead? Is it someone that, you know, they actually primarily live, and then going through the definition of what that means and why we think that it is. The point that we talked about with the equestrian training facility, and was that a commercial use? Not subject to devise, we covered that. Size and the low fails. I think we did a pretty good job going through all of the homestead section and then going through the status of the various judgments. I like how Jennifer kind of categorized, and we'll share this answer as well as mine afterwards, but I like how she characterized the ad valorem taxes and the special assessments, then the voluntary liens and the federal tax liens and other liens in a different way. And so you can kind of see how she broke those down and to each one of the bullet points. And so I think this is, from a practical standpoint of how you're writing your essay question, I think this is a really good idea. You see that she's got the titles, which I told you I adopted myself when I wrote my essays, but these are the exact questions that come from the call of the question. And then within that, it's just in outline form. So while I'm scrolling through this, if there's anybody else that saw any other facts or any other points in the question, go ahead and raise your hand and we can talk about that. Oh, this is one other point that I do want to reiterate. So homestead, in order to meet the definition of homestead, you have to be the owner of the real property. And you have to be a natural owner, or at least a natural owner with a beneficial interest. And so there's a myriad of ways that the facts could possibly bring that in, where it could be a trust, but you have to make sure there's a beneficial interest. And it can even be homestead property if there is a life estate, so long as the life estate holder doesn't have modifications to the life estate. They have to have the right to possession and the right to use. So if they have that, then they're entitled to it, the homestead protections. And so the reason why the wife's debt can't attach versus the husband's debt not attaching, so the wife is obviously deceased, and so her creditors are exempt from the forced sale of her as the owner. But then the husband becomes an owner of the property, and in doing so, he either has a life estate or he is a tenant in common, and it is in fact his homestead following the wife. So the wife was the owner, and so long as she was alive, then there was that protection that attached. Husband now gains an interest, and with the husband gaining that interest, he also cannot have it attached because he does in fact live there. And I like how she summarizes conclusion, the judgment does not attach. I hope I say this right. Shazare, is that correct?
Cesare, but we can just use Ches.
Okay, Ches, I love that.
So as we're discussing this, I'm like kind of becoming more and more aware of how many different routes you can take in analyzing all of this. Because specifically, I just wanted to jump in at this point where we're talking about this $500 judgment against the husband and wife, because we did kind of just discuss, oh well, they installed this equestrian training facility. It might have been for commercial use and therefore wouldn't be homestead, which would then take us back to, well, her will comes into play, which divides the son one subject to creditor claims. So like I feel like we could easily get lost in weeds. How do you guys suggest kind of following something a little bit more like hitting the topics that we want to hit?
So I think that as to this one, I think there's some things that are going to be clear in your question. If any of the other panelists want to jump in, feel free. But my opinion is that when you have something that you know is a certainty, accept that and take that. If you don't know, then discuss that you don't know and why you don't know and what might make it a different way or what facts you need to know. So in this case, I think we do know that the wife's devise is no good because automatically minor child, devise of homestead, no go, all stop, we're not going any further. That's going and test it. Husband is going to get some interest, whether it's going to be a life estate or whether the facts that we have to take as they give them to us. And so when you know that the will is not going to be an issue, then I wouldn't discuss that issue. When you discuss something previously, such as whether the equestrian facility is part of the homestead or not part of the homestead, I would only include that discussion as to the facts, in depth in one place. And then I think later you can make a very simple reference back that says, but as discussed previously, if the equestrian facility is determined not to be a part of the homestead, then this could be such and such. Or if we don't think that this is going to attach, but if in fact this bank judgment is for improvements that were also part of the equestrian facility, that may be a way that it doesn't attach. There's different ways that you could go about that, but we're saying because it was in the name of the husband and wife, it really doesn't attach. And so you really need to get to the heart of it. And those other facts as to this one really don't change what the conclusion is. And so if you can focus on the primary homestead issues, make a definitive determination, I think that's the way to go.
Can I interject for a second?
Sure.
You should, when you're writing the exam, you should just picture that there's graders in a room that are reviewing it and they have a checklist of issues. So what you should really do is make sure that you're issue spotting first. So you can basically say, oh, here's an issue, the ways you can go are this, and then you can put more detail. But the first thing they're going to check is, did you hit the issue? And then you can put the detail to it because they're just going through checking off lists. And then the more depth you go, it's okay. But the real first hit is to hit the issue, if that helps. That's more important than getting lost in the detail. You can say, oh, there's 4 options. I don't have time to go over them. It's okay too.
And I think that's exactly right. And I would also say in some of the essays, and not as much on the homestead, maybe it doesn't apply, but especially on your short essays, I think issue spotting is key. And I imagine if I was sitting in a room, your grader is going to say, like Lloyd mentioned, okay, you get the point for spotting the issue. Now, the next question is, do you know the rule? And I will tell you on at least 2 or 3 different places of my exam last year, I wrote, I see this issue. I think this is going to be the rule, but I'm really not certain. If this is the rule, that's how that would play out. And if this was the rule, then that's how it's going to play out. I mean, I think that the graders know that it's a very broad, I think that the graders know that it's a wide breadth of information that we're going to be expected to know. And I think you can't understand everything perfectly, but I would definitely not waste time in your answer because you will feel pressure and crunched for time. I would definitely not waste time discussing the same topic twice, only if you need to refer back to it and say, here's how the analysis would kind of change a little bit in my conclusion as to this particular judgment. Does that make sense? Does that help you, Ches? Philip, I'm going to go to you.
Hey, yeah, I just wanted to talk about the fact that the very first thing you brought up about having like an outline that you're gonna spit out, you know, where it's basically like, hey, it's a homestead question. Here's my homestead stuff. That stuff I did something very similar for the bar. You know, and a lot of like law school essay questions and things like that. I did something very similar, and it's always been super effective for me. And that really helps me make sure that I'm hitting fundamental things. And then all the weird little things I see, I know, like if I have time, I'll go into that. I just want to spot it. Kind of, that's what I was saying about the judgment. Was like, well, I don't know what that judgment's for. It could be anything. So I just, at the very least, was kind of like trying to separate out what that could mean. But I knew I didn't, you know, if I didn't have time to get into it, I at least just got it down. But then, you know, having if you have like a full outline of just the most fundamental stuff, that'll kind of help guide you of what you should probably focus on, if that makes sense.
Yeah, I think that's right. And I think it's important to note different sides. I mean, I would say they're writing the question in a way to allow discussion on several points that can go different ways. And so if you just saw this and went through the analysis without and gave the conclusion that it did not attach, without, you know, addressing that we don't know what the lien was for, and if husband and wife have voluntarily signed it to become a lien, like what if this was a foreclosure lien that's on the property with a mortgage that was voluntarily signed? I mean, that changes the conclusion. And so I think it's really important to list something with that, but I think that you can do that very briefly. I don't think that you have to get into all of the points at all. And I would also say, I think it's most important to go through the highlights. Like you're going to be prepared, you're going to study, go through and answer the questions the best way that you can, and then manage your time. If you feel like you have more time, read back through the fact pattern, add a couple more bullet points. And it's one of the reasons I really liked the outline form of answering the essays, because I didn't feel like I had to go work it into sentences within a paragraph. You could find that outline and you could literally go with the outline and pick the place where you know, you could just add a little bit more and maybe pick up those extra couple of points. David, I saw a minute ago that you had your hand up. Does anybody else have anything else that they want to talk about on those couple of judgments or in general? Go ahead, David. David, you're muted still.
What's that?
There you go.
Actually, when you scrolled the screen a second ago, it answered my question. It was more of an underwriting question, whether if the husband elected to take the life estate with the vested remainder, would those judgments still attach, and would it be an easier sale? You know, if you went to the developer and said, "Hey, husband, take the life estate," because then we don't have to worry about son one and son two's judgments. But it looks like when you scroll down, as I had my hand up, that those judgments still attach, regardless of whether they're vested remainder or they're contingent based on the life estate. So I guess it wouldn't really matter whether he took the tenant in common election for 1/2 and immediately passed their interests, or whether he took the life estate and sold it and had them join on the deed.
Well, complete full disclosure, we had a very big discussion about this. And so I think this is very detailed. I think that it's a really good point to bring up. Jennifer actually found a case that was directly on point, which is how we reached this conclusion. I definitely think that it would be a vested remainder, but our question was because it would be a full life estate, not an enhanced life estate, and the life tenant would have no ability to revoke the remainder. It would be fully vested. But I think the question then becomes, could you levy on a vested remainder? And the case that we found says that you would be able to. Obviously, at the foreclosure sale, whatever interest that purchaser acquired, they would get just what they had before. And so they would have a vested remainder, I guess a 1/3 vested remainder that they would hold as tenant in common. And then once the life tenant passed, then they would have the 1/3 interest in the property. But yes, as long as the bank understood what they were getting into, I think that they would have the ability to foreclose that interest. And I don't think that there's a way to eliminate that. So we would have to require, again, going back to the call of the question, we're representing a developer. And so the heart of all of that becomes, you don't want to have to go through this. Let's require that this is satisfied prior to closing.
No, thank you.
Of course. You guys have been so helpful. I appreciate that. Olivia, did you want to add something? Olivia, I see your hand, but you're still muted.
All right. Sorry, my screen like moved around. As far as the call of the question, it kind of goes into somewhat of a transaction in my like approach, not necessarily just legal, where they're coming to you like, hey, we want to close as quickly as possible. Is it worth getting into the facts, or is it not really worth time to delve into, hey, this is pretty complicated. This isn't probably going to get resolved quickly for the developer's standpoint? Or is it really more that the graders are gearing towards issue spotting and that's just going to be a waste of time?
I've never been in the room with the graders. I've talked to some of them. I've talked to some people that are on the committee that make the question and then ultimately grade. I don't think they're judging your ability to, I think it's the actual heart of the legal matters that they're grading on, not whether you would tell your client that this is going to be something that's easily resolved. Not saying that that's not something you would throw in there, but I think it's probably more of a, here's our model answer, like a checklist of here's all the issues that we think are here. How many did they hit? Was their analysis or rule correct on those issues? And how did their conclusion resolve the analysis between the facts in the pattern? Did they pick up on how some of those facts interplay with each other?
Okay, cool.
Does that make sense?
Yeah.
And then I would say down here with all of this case law, I think that that's excellent. This is definitely where Jennifer had time to go back and work at it. This is going to be an excellent resource for you guys looking back. But I think that there's lots of little things in here that I think this is where you could talk more. And I want more. You guys will give me just a quick second. I'm going to stop sharing because I need to open something else. Oh, yes. Okay. I don't have the other one, so I apologize for that. So there is another one of these that I did, but it seems like, oh wait, no, this is just the rest of Jennifer's. Yeah. So you can see back to what Olivia mentioned down here at managing client expectations. It's not a bad idea to throw it in, but I think when you look at the bulk of the entire answer, I think that it's important to note. I do want to go back real quick and make sure that I address one comment. So let me switch quickly to this. So when we were talking about my outline to memorize, I apologize, I don't remember who made the comment, but I don't know that it's necessarily a good idea to just mind dump. I use this more of a way to make sure that these are most likely going to be the topics that are addressed, and to make sure that I've considered them so that when I go back and read through the facts, you know, I want to make sure I'm thinking about, was it the residence of the owner? Is there an issue where the owner was absent? You know, we've all heard the story about the owner who went to the nursing home and then, you know, she passed away, but that if her intent would have been to return to that home, then she still keeps that homestead. So those types of issues I think are important to think about, and something that could maybe easily be overlooked when you originally read through a fact pattern. I think size is important. If you are in the city limits and you have 5 acres, it's really important to make sure that you brought that up and what that limitation is going to look like. The life estate interest, which we already talked about, if there is a life estate interest to the husband, so long as he has the right to use and possess the property, he can still have it. But I think it's important to not just mind dump and say what it is, but it's not just the rules that you want to be there. I think you want to make sure that you're actually analyzing them to the facts of the situation so that you can show that you picked out the pertinent facts, what the rule is on that, and then where that goes. I think that's really all that I have in this particular essay question. Does anybody else have any questions on this? Okay. I don't see any more hands. So I think I can.
Welcome to the voicemail box of Jeremy Sidran.
Caleb, I think I'm going to hand it over to you. I don't see any more hands. Thank you, everybody.
Think you did it with 10 minutes to spare too. Not bad.
Know, I'm saying. Really good luck on the exam. If anybody has any questions later, feel free to email me, reach out to me. Happy to help in any way that. Lucky you, you guys get Caleb now.
All right, but 10 minutes early too. How about that? So let me share my screen real quick. And this will be just basic info. So the homestead question, I always like the homestead question. So I enjoyed listening to Stephanie talk about that, because the homestead, I'm an underwriter with the fund. Homestead comes up, it gives people fits. So studying for this exam will make you give you a mastery of homestead with the way the fact pattern twists you up a little bit there. So mine is the transactional analysis question. I like this question because it isn't, well, to me, it was a brain dump for me. So real quick, as Stephanie alluded, I think the best way to tackle this question and the way I tackled it was I went straight to the call of the question first before I read it. So in our sample question, it asks, what's the basic due diligence that the buyer and the lender are going to require? That's number one. Number two, the advantages of a deal structure. So the advantages, disadvantages, transaction costs of the membership interest versus the property itself. In other words, instead of just buying the land, buying the entity to hold the land that holds the land, and the advantages and disadvantages of that. The third is the NOC, which we'll find out when we read the question together. And then number four, closing docs. So this question is great because I feel like it's target rich with points, right? You're just going to tell the graders what you know. So reading the question real quick because it's short. A seller is a Florida LLC that owns a retail shopping center that is leased to multiple tenants. The seller has no other real estate. The shopping center is part of a master property owners association that oversees several contiguous commercial centers pursuant to a declaration that, among other things, provides for cross access. The shopping center is encumbered by a mortgage with 7 years remaining on the term and a remaining principal balance of $5 million. The seller wants to sell the property, sell the shopping center to the buyer for $10 million. The buyer is interested in purchasing, but would like to minimize any avoidable transaction costs and avoid any unnecessary risk from the transaction. The buyer will need an $8 million loan to complete the transaction, has received a loan commitment for that amount from a traditional bank. So think your institutional lenders instead of your hard money. 1 month before closing, a roofer records an NOC against the shopping center based on a partial roof replacement that the seller contracted for and was recently completed. So from those facts, we know that we've got We've got tenants, we got NOCs, we got lenders. There's a lot here, right? So I remember when I took this test, and I took it 2 years ago before we had before the advantage of the academy. So this is nice that we get to talk about this as a group. I just took the 4 prompts, typed them in, and then I just, blacked out and gave them everything that I knew about these topics. Now, for our purposes, again, my outline is comprehensive. Again, I want to reiterate that when you see the outline that we're going to give y'all at the end of this, then we'll circulate the outline in the model question, the model answer that I crafted that was built on Cynthia Raleigh's hard work from last year. You'll see that it's comprehensive, right? But for our purposes, just so we can kind of talk about what you would think if you read this question, again, under test pressure, which is hard to replicate, but just sitting here, what are some of the basic due diligence items that you would want to see, from this for this deal? Does anybody have a kind of like what's some things that you would put in a contract that you would demand to see from a seller in a shopping center, tenants, anybody? Oh man. So I'm gonna go in order that it is on my screen. Cynthia, if you want to kind of throw something out there.
Yeah, I mean, obviously you're gonna want to see the leases, you want to get tenant estoppels, you want to do all your other normal due diligence, ESA phase 1, Alta survey,
Right.
those items. If maybe the seller has a prior Alta survey, if they had a phase 1 when they acquired it, if they'll provide those items.
Right. Now remember, you don't have to, when you're type, or at least when I type my answer, and I can't speak to how the graders grade because again, I'm not the grader, but I literally just listed those things out, right? So you talked about the tenant estoppel, right? Or tenant estoppels, you'd want to see the rent roll. You'd want to see in the rent roll any tenant, I guess what you would call like a tenant abstract that has any known defaults that are existent, monetary, non-monetary defaults. Survey, right? You want the survey, as expensive as an Alta survey is on a commercial piece of property, right? If we were told that our purchaser is sensitive to transaction costs, right? So we're trying to keep costs down. If we have an existing survey, you would take that survey to your underwriter and see if we can rely on it with an affidavit of no change, right? Environmental, anything environmental, notices, threats from local government, federal government, any of that stuff you'd want to know. Just going down my list real quick, I had existing surveys, environmental that you mentioned, the Alta. What else do we have, guys? Stephen, you want to throw something out there? I know we threw a couple out there. Do you anything else? And you're muted, Stephen, if you're talking.
Can you hear me?
I got you now.
Okay, sorry, it wasn't letting me unmute. I would want to see the association documents for the Master Property Owners Association as well. And we need an estoppel from them, obviously, but I want to see what they say, what the obligations are going to be monetarily over the years with respect to the overall project that the shopping center is a part of, who controls what kind of ARC review provisions there are and all of that stuff so I can advise the client.
Understood. Miss Eunice, what do you got for us?
Okay, I unmuted. I had pretty much the same list that was already mentioned. I don't know if anybody mentioned the actual physical inspection of the property during the due diligence period.
Yeah, you could ask for any existing inspection reports from the purchase, right? From when the seller purchased, right? Any historical existing property information is what you would want to see, right? David, what do you got? You got something else to add?
Operating financials.
Say
Want to
again?
know operating financials for the
Yep.
project, right?
Right.
like to see a title commitment. I don't know if it's premature for that. What else did I have? Service contracts. Want to know what you're going to be committed to, how long they are, when they all expire. Obviously, we would want an appraisal at some point to verify the purchase price you're going to be committing to.
Yep. So on my list, I had existing surveys, environmental, the existing title policies, any permits and licenses, building plans and specs. And again, guys, this is comprehensive, so don't I sat down very calm with a cup of coffee and typed all this out. So again, keep in mind that when you're taking the test. Warranties, inventory of personal property, management agreement, service agreements, as you said, development agreements, tax bills, any pending tax appeals, right? That's pretty common on commercial property. Everybody fights the value adjustment board. Utility bills, management agreement, did I already say that? And restrictive covenant. So that's what I had. That was my 10, 15 item list that I had from ours. Yeah, somebody said, and then I broke it down into historical financials. We had current budget for this year and the past 2 years, operating statement, general ledgers and balance sheets, current and prior year budgets, project capital improvements, historical capital improvements, tax returns, both from the property owner, entity tax returns, sales tax. I know we had mentioned the existing leases. Did anybody have anything to add on, I had an entire bracket on the existing leases. We know we talked about, known defaults, estoppels. Is there anything else in the leasing category that we would want to hit on? Eunice, you got anything you want to? You're at the top of my list. I can't see who raised their hand first, so go ahead.
I'm muted.
Yep, go ahead. No, you're not. You're good. Go.
I'm not muted. No, but I talked about before. Yes, estoppels on the tenants, payment history. And I think I mentioned earlier an actual physical inspection of the property.
Okay. Cynthia, anything to add to that?
Want to get some type of confirmation that sales tax has been paid. There's no outstanding tax warrant on all the sales tax due on all the lease payments.
Right. David?
Going back to the leases, with regard to cap rates and things, you want to see when they expire, what the renewal rates are, your ability to sign up new leases or renew them, and how far out each lease goes, and what you're committed to as far as the rent.
Understood. Stephen?
Are we talking about specific things we're looking for in the lease agreements, or are we talking about things outside of the actual lease?
Anything you'd want to know about the tenants and the leases, right?
Oh,
absolutely.
Absolutely.
This question is a little different from Stephanie's in that this is kind of like, tell me what you know about, it is a bit of a brain dump in my opinion, that this, just anything you have to add.
Sure. Yeah. I mean, in the leases, I would obviously look for ROFRs first and foremost, right of first refusal, right of first options, first and foremost. If there's anything in the leases, I would make sure all the leases are generally consistent with respect to the structure. You don't want to have a gross lease thrown in with a bunch of triple nets. Be a little bit strange. I would see what the maintenance responsibilities are for the tenants under the leases versus the landlord who's supposed to be taking care of what. I would want to make sure that all of the tenants have provided current insurance certificates, naming the landlord as an additional insured. That's a pretty big one. I would also want to double check any sort of exclusive use provisions, whether there's been any sort of, arguable violations that, might not necessarily be discussed in estoppel, but something that I think may constitute a violation. I would want to see exclusive and prohibited uses clauses to make sure they're all consistent amongst all of the various leases. And then I want to see what they all say about access, because the question talks about the Master Property Owners Association talking about cross-access between all these parcels, and I want to see what the parking rights are for each tenant, whether this cross-access easement is going to affect any sort of parking rights, anything along those lines, what rights these tenants have. Because if there's like a drive-through or something there, it may be affected by whatever's in the language of the cross-access easement in the owners association documents. That's just
Yep. Yep. The exclusives and the restrictions were the ones that stuck out of my mind, and you covered that. So on my list, we want to see all current leases and lease tenant files with the known defaults, prior estoppels, any financial information that we have on the tenants, because some leases do require turnover of financials sometimes, just depends on your lease. Prohibited uses, right? Incidentals to those prohibited uses, because it can materially impact who you can lease to, right? You may have the existing leases may pin you in a box as far as who you can lease to in the future. Any pending leases, and our delivery obligations, tenant improvement allowance if we're already on the hook for TI. You'd want to know that. The rent roll with the security deposit, again, this is a rent roll that we talked about earlier, but with security deposits, termination dates, option dates, rent, pass-throughs, anything like that related to the rent. Accounts receivable related to the tenants, age delinquency reports and write-offs. If we had a history where we've had to write off something with a tenant. Site plans, occupancy reports. Yeah, so I think we've pretty much covered that. And again, you mentioned insurance, right? The lovely world of insurance. We'd want to see all the insurance policies we can get our hands on. We'd also want to know loss history over the last couple of years, right? Because if you've had a recent loss, it's not practically it's not unheard of for a insurer to non-renew you, right? So there's that part of it. And then we also want to know any existing litigation. Let's see here. Allison jumped in there. Easement, zoning. Yeah, exactly. All of those things. I don't think, obviously there's the graders are going to have a checklist and there's going to be things that you want to hit. But I didn't mention all this when I took this test, right? When I was helping craft the answer, I realized all the things I didn't hit. Again, you're just trying to put as much as you can down on the paper. Because the problem with the test as the difficulty of the test, not the problem, but the difficulty is the time pressure, right? So you're just trying to stick and move and put as much as you can down on paper, so that way you can not only answer this question, but also get to the other ones that you're having to deal with. Other due diligence, some other things I wanted to mention that I had in a separate list. ADA compliance, I know that comes up. Allison mentioned in the chat zoning and all that. Yes, that was on my list. So when she typed zoning, it reminded me of the zoning letter report. One of the things about about the leases that hadn't been mentioned was subordination provisions. A lot of well-drafted leases have auto subordination language. Since we're going to have a lender, the question is, are we going to have to go get SNDAs, which y'all know can be like pulling teeth to get SNDAs signed? If we have leases that are self-operative on the subordination side, is the lender going to rely on it? Generally speaking, as an underwriter, I can tell you that we rely on that a lot of the times, but often the lenders say, no, we want our SNDA signed and we want it on our paper. So that's, something you got to deal with and can create problems. Then I had, let's see here. Some of these are redundant. Insurance, ADA compliance, UCC searches, liens, judgments. We already mentioned phase one. So yeah, I think we've covered it quite well. Now the other part of the first question is basic due diligence for the buyer. What about the lender? Now I can tell you, before I joined the fund, I didn't do as much lender work as I otherwise, would have liked. So is there anybody who feels comfortable answering if you're repping the lender in this, what you would want to see? And anybody, Eunice, you have your hand up already. I don't know if you meant to keep it up, but is there anybody that has lender experience that can jump into that?
Well, I'll just to start us off, I think obviously the lender is going to want to see the title commitment.
Mhm.
The more than likely is going to want to see the rent rolls you know, the estoppel letters from the tenants, the survey. Those are just some of the things that I would have there.
Okay. I had that the lender would want to see financials for the buyer and the guarantor if applicable. Of course, the since we're dealing with we may be dealing with the we'll get to this in the deal structure side, but we may consider buying the LLC rather than buying the land, right? So we would want to know if we're going to have somebody sell us the entity, or even when you're dealing with the sale of the land, you got to confirm a parent authority, right? So we need to make sure that we have evidence of authority of who's going to do all this for us and sign all the docs. And then, of course, for the lender, you're going to want judgment and lien searches for the buyer, right? And a lot of that's accomplished in the title commitment, the title policy, because your underwriters do run judgment searches as long as we have a buyer name on the front end. I know sometimes people buy them or put them under contract to sign them, put them in a SPE, special purpose entity. You know, so I know a lot of that can be fluid when you're in these deals, but that's just some of the things that I had for the lender. Does anybody have anything to add to that on the lender side? Again, the lender rep stuff is not my strongest point for me. So if anybody has anything to add. All right. So hearing none, on to the second part, the advantages, disadvantages, transaction costs of buying the LLC membership in comparison to the land. So does anybody have thoughts on transaction structure versus buying the land versus the LLC and the advantages? Let's start with advantages of buying the membership interest of the LLC rather than the land. Anybody got any thoughts on that? Steven, you go ahead and jump in there.
You might be able to avoid the imposition of documentary stamp taxes if you're buying the LLC that already owns the land, as opposed to like a drop and swap and forming a new LLC. I actually just talked to the DOR about this a couple days ago.
Pretty good, pretty good. So, yeah, so exactly, you would avoid the doc stamps, right? Now, when we were, one of the things that I missed, and I didn't even think about this until we started doing this outline, was that there's no doc stamps on the deed if the entity is not a conduit entity. Now, I've never personally run into a situation where we ran afoul, or I've never seen somebody running afoul of the conduit entity rule. Is anybody an expert in doc stamps and knows kind of the ins and outs of that part? Has anybody run into a deal where you had a conduit entity?
This is really common, Caleb.
Yeah.
When you do what Stephen was talking about with the drop and swap, when you do a drop and swap, it's a conduit entity. The
Okay.
conduit entity statute was drafted because the state was losing so much revenue because people were just taking properties and they were just not wanting to report the transfer in the real property records, and they didn't want to pay the doc stamps. So they would basically strip off the mortgage on the property, contribute it into a new LLC.
Which hence the drop and swap. Yeah,
right.
I got you now. Yeah. Yeah.
And so this was a compromise that was done by RPPDL, principally Bert Bruton, where basically they said, okay, what we'll do is we'll give you a 3-year window where if you do that and you don't transfer it within 3 years, then you're free. But if you transfer for the membership interest for consideration within the 3 years, then you have to pay transfer tax as if it was a sale on the doc stamps on a portion of the interest transferred for consideration.
I appreciate you, Lloyd. Yeah, I hadn't run in. I hear you that it's common. I hadn't actually seen somebody.
It was a lot more common before they passed the statute, but still sometimes people use it just to avoid reporting the transfer in the real property records, because they don't want to give the tax assessor a basis for seeing the valuation.
Yes, sir. Yes, sir. So the tax appraiser doesn't get a bite at the apple based upon the arm's length value. Yeah.
But the definition of a conduit entity is a transfer that's done without full consideration. So without full consideration could be either you had no debt on the property, or you had debt, but you only paid doc stamps to the extent of the mortgage. Either of those would be without full consideration.
Well, thanks for the master class on conduit entities, Lloyd. I appreciate you.
No, they're one of the great toys.
I hear that. All right. So what's some other advantages of buying the membership interest? So we've got the no doc stamps with the caveat of the drop and swap conduit entity. What about what are some other savings that we would have if we're buying a membership interest? Does anybody have any ideas on that? Go ahead, David.
A quick question while Lloyd's down there on the bottom of the screen. So if you have the $8 million mortgage that needs to get paid off, or whichever mortgage the seller has intact that needs to get paid off at closing, even if you buy the entity, you're still paying doc stamps on the value of the outstanding balance of that mortgage?
When you contribute the property encumbered by a mortgage into the entity, you have to pay doc stamps to the extent of the mortgage. It's a set of rules that came from when, before I've been practicing for 40 years, before I started practicing law, which was that when grandma gave her house to her children, they treated it as a gift to the extent of the equity and a sale to the extent of the mortgage. And that's really what came down in the case law for the transfers properties into entities. So it's deemed as a sale to the extent of the debt, the mortgage, and then a non-taxable event for the contribution of the unencumbered portion. The other thing that's been really a very hot issue lately is that whereas historically until 2 or 3 years ago, the property appraisers would just check the box and say, okay, now somebody sent a memo to all the property appraisers, and starting like 2 or 3 years ago, when you do that conveyance into the SPE, the conduit entity, they are now using that as an opportunity to reassess the value of the property, to remove the 10, on residential, you have the 3% cap. On commercial, you have a 10% cap. They use it as a chance to reset the cap. So it's one of those things you have to use as a factor in deciding what to do. It wasn't part of the equation before, but clearly they're permitted to do it by statute, and they're clearly aggressively doing it now.
In this scenario, let's just hypothetically say the seller already owned it for 5 years, so it's not a conduit issue.
Right.
But you still have the existing $5 million mortgage, and the beneficial ownership of the LLC is going to change, right? Because you're introducing a new member, right?
Mm-hmm.
New membership interest, and you're paying off a mortgage, you're satisfying a $5 million mortgage. Are there issues related to paying doc stamps satisfying that mortgage when the beneficial ownership changes?
If you're not a conduit entity, if you transfer more than 50%, and the threshold is 50% of the entity, you're required to file a form. I think it's a 400.5, which the year before they adopted the conduit statute, they adopted another statute which says that if you transfer more than 50% of the entity, you have to tell the property appraiser, and they have a chance to reassess the property. So if you had an entity which they don't pay full consideration when they bought it, or had it for 5 years, regardless of its conduit entity, you wouldn't have to pay doc stamps on the acquisition of the membership interest, but you would have to report the change in ownership to the property appraisers. And again, 5 years ago, or 10 years ago, they weren't very good about reassessing the properties. They're much better at it now. They become better at their jobs. We don't fault them for it. We just don't like it.
All right, Steve, you want to jump in there?
Yeah, I actually just asked this exact question of the DLR because one of my clients is dealing with this exact situation right now. If there's no deed and it's not a conduit entity, doesn't matter whether the property is encumbered or not, no doc stamps are due, but you still need to file the DR 430.
Yep, you beat me to it. The DR.
That was the number, Stephen. I couldn't remember.
Yeah.
Thank you.
You beat me to it. I
Fresh in my mind.
was about to drop it in there once. I was going to let Lloyd finish his master class on doc
But the sanction for not doing it is really high, which is that they get a 10-year look back from the day you do it to reset the value of the taxes. So And it's the different property appraisers have different interpretations. Like in Palm Beach County, the property appraiser takes the position that if you transfer 50% exactly, you're not required to report it. But what the statute and the administrative code say, if you transfer in excess of 50% since it was last assessed at fair value. So the question is, if you do it over 3 or 4 years, are you required to report the cumulative transfers? And the property appraisers around the state are inconsistent on that. And so what we do is, because we don't want to have the risk of reassessment, we actually, when we do it, we file a notice that said we did it, but you're not entitled to reassess, because that way you can never get in trouble, except for the fact that you're kind of putting your head up in the wind.
Thank you, Lloyd. I appreciate you, man.
Sorry to interrupt.
No, sir. No, sir. I doc stamps was not my strong suit. When I attacked this question, I did not, I stuck to the high point, which was, you might have some savings on doc stamps. And once you looked at the response, the conduit entity, I realized I had a blind spot in my understanding of doc stamps. So I appreciate you. So as was mentioned, the DR 430, assessed tax cap can be reset. What other savings do we have other than doc stamps? The one that comes to my mind, just because I work for an underwriter, is you don't necessarily need a new title policy. Although, of course, the lender is going to want one, right? And you, depending on that old policy, depending on the face value of it, you may want a new one, right? And of course you won't get simultaneous issue. You run into, you'd have to play the numbers with the ratings department about simultaneous issue versus with or without the owner's policy. You'd have to kind of play with the math and see what's best there. We know that, the facts told us that we're going to purchase at 10 million. There's a existing mortgage out there with 7 years left on it at 5. If we're buying the membership interest, there is a possibility that we could assume the loan. Of course, we'd have to go through that process to see if we could get the loan bought from one lender to our lender at par value, right? And the ability to assume that. If the lender permits the assumption and increases the principal balance, they would have to modify, increase to 8 million, right? And then assignment of all those loan docs. I have not personally been, like I said earlier, I haven't personally been a part of that process before, because I didn't do a lot of lender rep before I joined the fund. I don't know how technically difficult that is, and how much of a headache that would be to get all that, the loan bought at par and all the docs transferred. I don't know if that's a hard landing to stick or not, but it's possible, right? Some of the disadvantages of buying the LLC interest. Is anybody? And Lloyd, I saw you read it. Are you going to jump in there real quick?
It's okay. You're doing great.
Okay. These were my blind spots. I just admit up front, because you didn't, admit up front that they were not mine.
That's the point. Is it, nobody expects anybody to know all the answers. The point is to point out the issues, and you'll get a lot of points just for raising the issue. And it's okay to say, I'm not, my instinct is this, but I'd have to go back and check, because this test is nobody practices law knowing everything. Everybody practices law by being able to recognize the issue and go out and check on it. So the test requires a base knowledge, but once you pass the base knowledge, then it's okay to say, I recognize this issue. I'd have to go find out. Just like Stephanie was talking about before, where she didn't know how the judgment lien worked against the reverter interest in the homestead property. It's okay to say, I don't know the answer, and I'd have to go look it up. It's better than ignoring it, and you get points for recognizing the issue.
Yes, sir. Steven, you want to jump in real quick?
Yeah, I mean, if we're talking about the disadvantages, the biggest one is you're assuming all of the liabilities of the existing LLC, which is huge. You have no idea what those liabilities are. They may not necessarily be recorded. Somebody could have slipped and fallen in the shopping center, a month beforehand, and they may file a lawsuit after you close, because they're still going to be well within the statute of limitations, and let alone every other liability in the world that may exist in favor of that business. And then if it is a drop and
Understood.
swap and there is a conduit entity involved, then it's going to really affect your ability to sell the property for the next 3 years, because you may have avoided the dock stamps now, but then if you don't hold it for more than that 3-year period, you're going to end up paying dock stamps if you want to sell it within that 3-year period if you are a conduit entity. So there's a lot of disadvantages
Understood.
with it, huge ones.
Yeah. So I had, exactly that, when you're buying the entity, you're buying the assets and the liabilities, right? So you've got reputational risk, you've got litigation risk, you've got environmental risks, right? There's also the liabilities that the members or managers of the LLC are not even aware of yet, right? The unknown unknowns, right? That's a big headache or a big risk. And then how do you craft a deal around that? Right? Do you put together an escrow? Do we do indemnities with a cutoff? Like, those are all have to be negotiated. Again, as Lloyd pointed out earlier, you issue spot it, call it out. Stephen, as you did a great job breaking that down. The other issue is the lenders may not want to lend that structure, right, of buying the membership interest. They often prefer the acquisition of the real estate, right? Not that you can't do it this way, but they may just prefer to have you buy it and rather than the acquisition of the membership interest. Also, there can be a lot more moving parts in the LLC purchase, particularly with multi-member LLCs, multi-member than the layers of the multi, right? So there's just a lot that can go in that can balloon when you're having to go through layered entities. So what's the does anybody have anything else to add to that? Again, my list isn't perfect or comprehensive, so if anybody has anything to add to that list, speak up. Olivia, what do you have?
I agree I think you touched on it just now as far as potential conflicts between members. You're buying into an LLC. So if you buy into this LLC, there's this unknown of who you're now getting into business with as far as agreements, as far as tenants, who are we agreeing to, how are we marketing the building? There's just so many layers on a business standpoint that I don't know if the cost even makes sense to set up an agreement, because it would have to almost be so detailed that potentially could offset any savings of just purchasing the property and retaining the control over your acquisition. Maybe it's because I'm a control freak, but that would seem to have a little bit, that would give pause. Or if now you've bought an ownership interest, what happens if one of the members now wants to sell the building, and how has that been structured in advance? It seems like you're going to have to put so much time and cost into setting up an arrangement, if it's to be that detailed, to avoid issues, that I just feel that might offset it.
Right. So you save this money over here on dock stamps and maybe a part of a title policy, right? But then you got to pay lawyers to comb through this and to create this structure. I don't know if you're just pointing all this out, right? The question just says, let's discuss the advantages and disadvantages. You might eat up your savings in over here having to lawyer this thing versus, right, your dock stamp and title policy savings.
So
ahead, Lloyd.
Caleb, can I say something? Olivia, I think that you have a misperception of the question. I think the question assumes that you're going to buy 100% of the membership interest of the LLC. And so if you don't have the issue of with the prior owners, you'll have the same group that you would have had whether you bought it by deed or by membership interest.
Okay.
So, but there's one issue that nobody's really talked about, and I didn't see in your answer, Caleb, which is really important, which is it's really a significant disadvantage for the seller to sell the membership interests. And the reason that it's such a significant disadvantage for the seller to sell the membership interest, and this is what you'd point out, is that then they're selling their stock, their membership interest in the LLC, and they have personal liability for that to the buyers versus having the installation of the company. Right? So if there's one shareholder member in the LLC, and that one member sells its membership interest to the new buyer, well, then you actually have a membership transfer agreement, and that individual signs it personally. So they're now on the hook, and they're going to make a representation that there's no other obligations, and they're going to be on the hook depending upon how you negotiate it for those obligations. So there's a significant exposure. The buyer has the exposure for the unknown liabilities, and the way they cover that is by the promises from the seller that there are none. And if you have, then that seller is basically undertaking the guarantee of that in a normal document. So there's a lot of exposure on that side as well. Like when I do these and I represent a seller where we're selling the membership interest, I generally transfer all the membership interests from all the multiple members into a single member entity before we do it, so the individuals don't have that liability. And so that's a great point to talk about when if you get a question like that for an entity transfer.
Good stuff, Lloyd. Yeah, you're right. I didn't have that. That was the extent of my pros and cons on the membership side. And I didn't think about the personal liability. Lloyd's over here holding master classes on doc stamps and deal structures. So how about buying the land, right? What's the advantages of buying the land? And anybody can just jump in. We can go loosey-goosey. Go ahead, Megan. Let me see if I can unmute her. You're away.
So you start fresh with a new entity. If you're going to, do a special purpose entity, and banks always like that, there's no liabilities or other issues.
Right. So you don't inherit any of the stuff that we just talked about, that Lloyd held a master class on. We don't inherit any of that stuff, unless we agree to, right? Also, if the seller is a collectible entity, right? They have an easier recourse against the seller if something comes up post-closing, right? On some of those reps and warranties that survive closing, on the contract, you have, if the entity is still going to exist, we have something we can go after. What about some of the disadvantages of buying the land? I mean, the obvious is you got to pay doc stamps, right? We talked about all that structuring to kind of get out of the doc stamp thing, and now we're back to paying doc stamps, right? But there's something for that, because you're not inheriting all of the negatives that we talked about earlier. Oh, and also, you're having to pay for a new title policy. Now, again, you'll get simultaneous issue with the loan policy, and we've got, we've recently gone to a new jacket. So depending on how long the previous entity held that property, you may be dealing with an older jacket that maybe has less coverage. So there's advantages to being in a brand new policy with the increased coverage that comes with the new jacket, with the 2021 jacket. So before we move on to the NOCs, or NOC, I should say, does anybody have anything to add to anything we've said so far on deal structure? Again, thanks, Lloyd, for jumping in there with me on those. That was I learned something today. So anybody got anything else to add? All right, NOCs. So we're told that, let me scroll back up here. We're told 1 month before closing, we got a roofer, we got an NOC, we got a partial re-roof that the seller contracted for and was recently completed. So I would say up front, as everybody may or may not be aware, there was a recent change in the NOC statute. The old school stop start, we don't have to do that anymore, which is nice, right? Because I mean, I've personally seen deals where the contractors didn't stop, no matter, they still didn't stop even though we went out there and posted the termination. The guys are still out there working. So I guess maybe the statute was a recognition of the practical, which is sometimes these guys weren't stopping their work anyway. So we don't have to do the stop start anymore. Does anybody feel comfortable kind of talking through some of the points that you would want to see? Because again, we're going to have a lender, so we got a lender that's going to have to be in first position. David, you want to jump in and kind of walk us through your thoughts on that?
seem to get stuck with these all the time every time I have a loan. First of all, the contractor who's in direct contract with the owner, what we have is a notice of termination with a contractor payment affidavit attached to it as an exhibit. And then for all the subcontractors who filed notices to the owner, and we need lien releases from each one of those. The notice of termination doesn't expire, unfortunately, for 30 days from the date it's recorded. So we typically would have an indemnification as well, which is as valuable as whatever that may be, but for the owner indemnifying the title company and everybody else that in the event something happens. And then the other issue is there could be subcontractors that record it or that serve notices to owner after the date of notice of termination. And we also have to make sure that we address those the same way and terminate those.
Yep. So we've got, as David correctly points out, we've got a contractor who's got contractual privity, right? And they're the one listed on the NOC. They're the ones listed on the NOC. If they're subs, the subs establish contractual privity through the notice to owner, right? So we gotta cover it twofold. We got to deal with our GC and make sure he's been paid, and we got to deal with our subs and make sure they've been paid. Usually you request from your GC a list of who's worked it, and you kind of reconcile those two things with seeing maybe what your notice to owners have come in and who's provided those, if any. Sometimes there's none, sometimes there's a lot. And then seeing who the GC says has been paid or not been paid. And then you got to make sure before you close that all those people do get paid through the date of closing. Again, in a world where there's no stop start anymore, you're just trying to get them paid as close to closing as humanly possible. And then, like David said, that indemnity for what it's worth, right? You just, you do everything you can to get that cleaned up. Your lender's going to want a title policy ensuring their mortgage in the first position. You terminate the NOC. As you pointed out, the NOC has a 30-day tail. That 30-day tail, you deal with that with the title policy, right? You give them a title policy that doesn't show an exception or pro forma ahead of closing, whatever. Let's see, lost my place. So you want to make sure, based upon the facts, it looks like the work may have been completed, right? These people may have already been paid, if we're lucky, if we're lucky. So, I think you would start by asking, when was it completed, evidence of completion, payments, receipts, NOCs, or sorry, not NOCs, notice to owners, releases from the GC, etc. You would terminate the NOC, slap the contractor's final affidavit to the back of it, like you pointed out. You would follow the procedure. And guys, you don't have to remember statutes on this thing, but the statute 713-132. If our closing is occurring more than 30 days after the termination, that would be nice, but that's not, that's not, we don't always have that advantage. If the termination is happening in the window, you'll have to have that indemnity, right? As David alluded to. So, and again, your indemnity, just a plug for the title insurer, your indemnity, get that form approved, or let us have a look at it with you before you, because we want to make sure we're in there too. We have our own indemnities. For example, the fund has form indemnities. So just keep that in mind. Think about your underwriter when you're getting your indemnities or when you're doing your indemnity. And I think that would pretty much cover your NOCs. That process we've all dealt with at this point. I think probably the stop start, again, recognizing that people really didn't always stop. So there's that part. What about the closing docs? So this is, again, another kind of brain dump. What docs would you want to see drafted if you are the buyer? What docs should be required? Anybody can just jump in whenever. Obviously, you're going to want a deed, right? What else do we want? Eunice, you can jump in there.
I mean, some of these things we had talked about earlier, the documents that we want to research, but the estoppel from the tenants, the estoppel from the association,
Mm-hmm.
LLC affidavit. Obviously the release and the affidavits from the roofer, payoff information, final closed permits. I know some of this is repetitive from what we
Yeah.
got. Those items that need to be looked at. I would require as a buyer from the seller.
Right.
Along with the regular closing document, you said the deed, the gap affidavit, those type of affidavits.
Okay. Yeah, so I had closing statement, deed, owner's affidavit with representations relating to possession and no liens, right? Again, recognizing that there's tenants. Assignment of contracts, terminations of any contracts that are not being assigned. Assignment of leases. Again, assuming we're not buying the entity. Estoppel certificates, as you pointed out, estoppel from the POA, showing no assessments, no arrearages, no violations. Title policy, you would want to get the cross-access easements insured, right? Affidavit, FERPTA affidavit. I think that's about. And also documents confirming actual authority, right? I said that earlier. I think again duplicative, but you would want. Stephen, go ahead, jump in there. You don't have to raise your hand if you don't. Just leave. You can take stuff off mute and just talk if y'all want to.
Okay. Assignments of permits, licenses, and warranties also.
Ah, yes. Yeah, you. I did not have that one on here. Correct. Yeah, you would want to, because I talked about we talked about the permits earlier on the basic property information, but yes, you would want those assigned. Correct. What about the seller? Seller, of course, closing statement. What else? Evidence of authority, good standing of the seller entity, FERPTA, releases of anything that we're getting released as a part of closing that's a deliverable. And then what about the lenders, guys? What would you want to see from the lender standpoint? What's the lender going to require? They're going to want a mortgage. What else?
Assignment of rents and leases. Obviously, they're going to want their pro forma loan policy and any endorsements required with the type of loan. They're going to want to see not just the assignment, obviously the assumption of the leases as well.
Right. Yeah.
EAs, of course.
Exactly. Yeah. I had a closing statement, mortgage security agreement, promissory note, assignment of rents, collateral assignment of rents, right? Loan agreement. Sorry, that probably would get wrapped into the previous agreement. UCC 1, environmental indemnity, guarantee if applicable, title policy. Of course, they're going to want their title policy to show all these tenant leases subordinate, right? That's we talked about the SNDAs earlier, proof of insurance, rent roll, etc. That is, anybody got anything they think I missed?
I had a question, Caleb.
Sure.
And you may have already addressed this with the other items, but did you take the time to explain why each of these documents were necessary or just listed them?
When I took this test, I just rattled them off.
Okay.
Not that there's, I don't know if there's points in explaining the whys, but it asked, the question says, what closing documents should the lender and buyer require? It didn't say and explain why, right? So I just rolled them off in list format. So I did not, when I remember when I this part of the tick, because by the transaction one, that was the one I was most comfortable with. I don't remember explaining the why the documents. So I think that's about it. I will tell y'all, I think I got a little bit of time left. Prep. I took this test 2 years ago. Again, I didn't have the benefit of the academy. I have children. I studied for this test basically every day for 2 hours a night from the day of the board review class to the test date. And I studied the board review materials from the class that you, or from the CLE class that you guys took before this. And I reviewed the title notes, and that was about it. That's how I prepped for it. So if you have kids, I get it. It's hard. You know, I'd put the kids down at, like, my wife would put the kids down. I'd say goodnight and then come back down about 8:30 and just study for a couple of hours until I couldn't keep my eyes open. So, yeah, so that's how I prepped. Anybody else have any questions?
I have a question about scoring. So there's a total amount of points available for each question. Is that then like split into a total amount of points for each subcategory within the question? So for example, the doc stamp analysis that we just went through, I'm super familiar with that. So is it worth going super in depth into that, or is there only a finite amount of points that we can get for the doc stamp analysis versus the other things? Or can we make up extra points doing an above and beyond analysis in one area versus another? How does that work?
That's a great question. I don't know. I mean, when I took the test, if I was strong in something, like obviously I didn't know doc stamps as well as you do. So I stuck to what I know and I just hammered what I knew. I mean, if I knew it, I put it on paper and I tried to, I was watching my time to make sure I wasn't spending too much time on something, but I tried to, if you're strong in something, I don't know that there's a disadvantage to showing that you're strong in it. You know what I mean? But I don't know what the sub brackets are. Your question, like, are there sub brackets of what these things are worth? I think that part, I don't know. I know what the overall question's worth that they went over earlier. They talked about how many points the transactional question's worth. I don't know what the subcategories are worth. But I think it's like a law school exam, right? You're awarded points. I don't know that there's a disadvantage to showing that part.
Thank you.
Yeah.
Question from Lloyd.
Yeah, I'm here.
Do we have access to the video from the class we just sat in a couple weekends ago? Or is there a video?
Jeremy, are you on? Jeremy? There is a video. I don't know about the access to it yet. We will check with Jeremy Citron, who's that real property one, but only half listening. So to find out what the availability of the video is.
To mention, in case it helps anybody else, I also took the class from 2024, and I was able to spend another $20 recently and renew the video. And they also can release it so you can scroll through it rather than having to watch 14 and a half hours starting from the beginning. So it's been very helpful for me to actually go back to different sections that I wasn't as strong on, and to start rewatching some of those videos. So just food for thought for anybody else.
Were there more? Oh, sorry. I was just going to ask, following up his question, were there more chapters that went with the 2 new videos that we got released?
Basically, if they did not give you what happened when we built the seminar starting in 23, I think, was we found that every year all of our speakers always ran over the time, and I would give them the speech all the time that said, you have to give as much dignity to the end of your presentation as your beginning. You can't cover the last 30 minutes in 10 minutes, and they never would do it. So what we did was we created this idea of trying to give everybody more time by taking out 3 or 4 sections every year, which didn't change. Bankruptcy didn't change, or zoning didn't change, or MARTA didn't change, depending upon which year it is, and said, we're just not going to give you that. We're not going to give you that section live. Instead, we're going to give that as a video and give all the other speakers more time to speak. And those materials should have been included for those sections in your original materials. And if they weren't included, if you tell us, then I will make sure that everybody gets those materials as well, because they're available and nobody updated those materials. So it's the same materials from 2024, and that should have been included in the package you got in 2025. And if it wasn't, then we can make those available to you. So if you send me an email or send anybody on the group an email, we will take care of that for you. But I would hope that they were included in your original package. I think this year it was bankruptcy, land trusts, zoning. I forgot the fourth one. I'm sorry, but
Now, I did receive an email from, this is Eunice, I did receive an email from Jeremy with the link to videos for some of the topics that were not covered in that seminar we had back now in February.
Right. But my question, Eunice, was when you got the materials for the seminar that we went to in February, it should have included those materials for the ones that you got the link for. If it didn't, then that was a mistake and we need to get those materials. But I think that it was supposed to be included in the original package that you got for the February seminar. So you would have gotten those materials as part of the original package.
I'll go back and check and send you an email.
Thank you.
As an example, I don't see bankruptcy as a chapter. So
Okay.
maybe it's not. Yeah.
So if bankruptcy isn't there, if zoning isn't there.
I don't see them. I don't see
okay.
land trusts. I don't see zoning.
Thank you, Eunice. Thank you, Stephen. We'll get those sent out to everybody.
All right, any other questions generally or related to the transactional question before I hand it off to Cynthia? Anybody got anything else?
I want to go back for a minute to the NOC
Yes, sir.
stuff and give guys a practice pointer and something that's great to talk about on the exam. And that is, if you know you're going to be doing a closing, if you know you're going to stop in the middle of construction, one of the great practice things to do is to modify the form notice of commencement and put a shorter maturity on it. So the default in the form, it says 1 year, but we had a closing and we knew we were going to close on October 15th. So we made the NOC expire on October 15th. And then you don't have to do a notice of termination. You still have to do the indem, but you don't have to do the payments. It's a much easier process. And it doesn't work perfectly because what happens is if you end up not closing on the 15th when you expect to, you have to go ahead and make sure you amend the notice of commencement to extend the date and you have to do that before it expires. Because if it expires, you have to do new NOC because you can't, if you don't have an NOC, then you have what's called unpermitted payments and you have a risk. But it's one of the tricks that we use, and we especially use it in just the normal things when your clients hire the HVAC guy to go put in a unit on the roof. You say, how long is it going to take you? And if they say you need a month, and you say, okay, you put 2 months into the NOC, and then basically 8 months later, when you're going to close your loan, if it's expired, it doesn't matter. But if you let it run for a year, you have a problem. So it's a great thing to talk about in your answer is the flexibility by putting in the short time. Now, there are some underwriters who will go unnamed who don't like that. They think that there's no authority in the law to allow you to do it, but most underwriters will allow you to have the shorter time period, and they'll still require indemns, but it gives you a lot more flexibility and a lot less pain in the transition. The other thing that I wanted to talk about is when somebody talked about now discussing the documents, it's a really good thing if it's a commercial question to say it wouldn't be appropriate to have a full warranty deed because the standard practice in a commercial transaction is a special warranty deed. That's just like a good free shot. Sorry, Caleb.
No, you're good.
Okay.
Yeah, I didn't say special warranty deed. Of course, that'd be driven by your contract and what, a lot of your contracts have a form deed attached to it. If you've done a custom commercial contract, but yeah, I mean, if special warranty deed, yes.
Right.
Yeah.
If you're asking for a general warranty deed in a commercial transaction, you're not a higher level commercial transaction provider. It's not the norm.
Right. Exactly. Anybody else got any other questions they want to throw out there? I know that's a lot. I mean,
Megan.
again, that question is big time, show me what you know, throw everything out there type of thing. So anybody got anything else?
All right, I kept my hand up from before.
Megan, you good?
Yep, that was never put it down. Apologize.
Okay, okay.
All right, well, guys, I give y'all thanks for listening to me talk, and I give you now the great Cynthia Raleigh.
So this is an ethics question, and it's if you know the basics and you paid attention during the review course, in my opinion, the review course, the ethics section of this was really, really well done and very helpful in answering the actual questions that you got on the exam. With that said, does anybody need a couple minutes to read the question? Because it's a page and a half long. And I wasn't planning on putting it up, on sharing it on my screen. So raise your hand if you would like 60 seconds to skim this question. Otherwise, I will get going. All right, one of the other Cynthias. Okay, so I'll share my screen and I'll give you guys just a little bit of time to take a look at the ethics question. Okay, so I'm gonna get started. So this is just your basic, how do you plan an essay answer type of thing? You read the question, spot the issues. There's a tool in the exam, if you're doing it on your computer, there's a tool that I like to, it allows you to highlight and make notes. And then apply the rules to the issues. And this is especially important in a question like this one, where you actually have rules with numbers that you can apply to issues. I'm not saying that you need to memorize the numbers or anything, but. And when I was thinking about how to answer this question, I realized that there's kind of a broad framework when you're answering something about ethics, because lawyers have a responsibility to the public. They have a responsibility to prospective, current, and former clients. And then we have responsibilities concerning our non-lawyer employees. And if you keep those three big issues in your head at all times, I think that you'll get a lot of points out of a question like this one. So we got part one of the question. And the great thing about this particular question is they tell you exactly what to talk about. So part one of the question is issue spotting. And they want you to discuss dual profession, conflicts of interest, and confidentiality. So dual profession. I'm just going to show you what I picked out of this. Clearly, Adam here is a lawyer and a real estate broker. So number one here, what do we want to talk about there? Anyone? Okay, so obviously dual professions are permitted. The rules allow that. So that's number one. Dual professions are permitted. But what are all of the things that you need to address if you are a lawyer who's also a broker? Lloyd, would you like to talk about this? I'm kidding. No, just talk about this. First and foremost. Oh, sorry about that. I went ahead too quickly. Preserving client confidentiality. That's really, really important here, right? Because you've got the people who are your brokerage clients and the people who are your law firm clients. They may or may not be the same people. And where the business is closely associated with the practice of law, and if you're a real estate lawyer, then your brokerage is closely associated, or your title company or something like that. It has to be conducted in accordance with the rules of professional conduct. That is the overarching theme kind of this question. One of them is that if you're a lawyer, and you also do things that aren't related to law or aren't part of your law practice, and you also supervise non-lawyer people or work with non-lawyer people, you got to hold yourself to the standard of the lawyer rules of professional conduct at all times. So Adam's a lawyer and a real estate broker. You want to pick that apart. Confidentiality, you got to conform your business with the rules. And a lawyer has to condition condition a consultation with the prospective client on that person's informed consent that no information disclosed during the consultation will prohibit the lawyer from representing a different client in the matter, right? So because lawyer and real estate broker in this circumstance, in the same office, could reasonably be confused by a potential client, that could lead to an attorney-client relationship forming in your client's mind, and that's really where it matters. Even if you did not intend it, lawyer. So as a lawyer, you need to make, Adam should have made reasonable efforts to avoid any misunderstanding here. And he does not appear to have done that. Anything to add about Adam being both a lawyer and a broker here? So on Adam's business cards, Adam has both roles on his business cards. This implicates advertising and the dual profession, and it's okay according to the rules to put both things on your business card as long as it's really, really clear what you are. You are both a lawyer and then you are a broker. Sorry, I've got a little delay happening on my end. The office signage. Again, you got to take steps to avoid misleading the public as to the business activities being conducted in your office. So signage for the two professions must be separate. Have one sign up here, and then Adam is good on this, right? Have one sign up here that says I'm a lawyer. Here's another sign down here, I'm a broker. And also regarding the signage, Adam and Zach together, right? A non-lawyer can't have an ownership interest in a law firm. So it needs to be really, really clear that Adam and Zach are real estate brokers and that Zach is not a lawyer. All right, and then we can move on to the receptionist greeting. The receptionist is answering the phone by saying Adam's office. That could be problematic. In and of itself, it's okay. It's not a direct violation of rules, but it could be problematic. And the receptionist should say something like professional offices, which you often hear when I've heard that a million times when I'm calling people's offices and they're sharing with other with the title company or with real estate professionals. And also Zach could consider 2 lines to ensure that the businesses are and appear to everyone, to the public, to be separate. But that's not required by the rules. So moving on to conflict of interest. After Sally listed her house with another broker, Adam met Beth at his office and is hired to find a house for her. So there's your fact. Sally, who is, I don't know, probably now a former client. We're not sure, but she needs to be treated as a former client. Sally should be treated as a client under the conflict rules. Is she current? Is she former? I don't know. You could address both. So going back to the framework for the ethics questions, prospective, current, former client, you can always talk about the rules for both and when and what you can disclose. So current client conflict. In a current client conflict, you are prohibited from representing a client if the representation of one client is directly adverse to another. So here, because Adam hasn't been careful in delineating his role to either Sally or Beth, we're going to apply, I would in this situation apply the conflict rules that apply to lawyers, right? Because if Sally thinks she's still a client, then she might not think that the representation is ended and by using another broker to list her house. So those 2 roles are separate. So this would make her a current client, and it's always the client's perspective that matters, not Adam's, right? I also made the note here that Adam probably should have declined to represent Beth. There doesn't appear to be a way for him to provide competent and diligent representation, which is, wording taken right from the rule, to both clients without asserting a position adverse to one of them. And that is obviously a huge no-no. You can't assert a position that's adverse to one client to advantage another one. So if he discloses Sally's confidential information, bad things about the house to Beth, he'll harm Sally, or he doesn't disclose it, which may harm Beth. So there's the conflict discussion based on the disclosures that Sally has given and taking Beth on as a new client. Former client conflicts. A lawyer who has formerly represented a client in a matter must not afterwards represent another person in the same or substantially related matter in which that person's interests are materially adverse. So you cannot. I think it's a worthwhile endeavor, especially in the conflict rules, to know what you must not do, what you can do with informed consent. That's worthwhile to know in analyzing a question like this. So for former clients, can't represent a new client in the same or similar matter, materially adverse interest to the former client. And you cannot, of course, use information that you learned in the former representation relating and use it in the new representation. So in this case, if we treat Sally as a former client, Adam violated the rules by representing Beth and using the information that Sally gave him about that house against Sally. Possible exceptions to this rule, and this comes from the comments in the rules. If that suicide is publicly known, it was in the news, or if Adam will prevent a crime or fraud by revealing the information. And that is another very useful part of the rules to memorize. What are the exceptions? When can you, quote unquote, betray a client's confidences? Crime, fraud is one of them. Moving on to the part C of this, confidentiality. First things first, Adam shares an office with a non-lawyer. That should set off all kinds of red flags for all of us. Now it's only on the weekends, and Adam's desk is in the main room. So what are some problems with this? It's pretty clear. You got to preserve confidentiality, right? So I would suggest locking files to ensure that Zach and Zach's clients can't access them, especially since Adam's desk is in the main room. And then confidential attorney-client conversations, such as those with Sally and Beth, have to take place somewhere Zach can't hear if Zach is in the office. Although that might not be a problem because Zach's only there on the weekend. So number 2, Adam meets with Sally at his office to discuss selling her house. This goes back to both the dual profession and the conflict discussion. So this brings in both of those. And there's a lot of overlap in these questions too, especially regarding confidentiality, because it really crosses everything here. But to make it clear, Adam didn't make it clear whether he had his broker or lawyer hat on. So lawyer rules apply again. And if they met on the weekend, it isn't clear whether that Zach was there, and if so, whether Adam and Sally's conversation took place in front of him. So those are some of the facts that I would address under confidentiality in this case. There's also a kind of an important issue, but one that I just added on here. Lawyers can't assist their clients in committing crimes or fraud, right? Is Adam helping to sell Sally's house without revealing the incident, assisting her in committing fraud? I don't know. I drop it into the question, into the answer though, for an extra point, hopefully. And we know Sally decided to use another broker 6 months later instead of Adam. And here we go again with a lawyer can't reveal information relating to a client's representation unless to prevent crime or fraud, death, substantial bodily harm. So, and Sally again is entitled to a assumption of attorney-client privilege related to the information she shared with Adam. And the facts also make it clear that it was important to Sally that the information stay confidential, and she did not give what? Informed consent. That's a biggie. Informed consent to reveal the information, which he did. There's all the applicable rules and ethics opinions for this part of the question. There are all of these ethics opinions, and I highly recommend going into the database of ethics opinions and looking at all of the real estate related ones. There are a lot, and they're all right on point with some of this stuff. Like all of these opinions address a specific part of this question. And then going over the confidentiality, the conflicts, the the duties to prospective clients, and then advertising. Really, really important. So part 2. In part 2, we have essentially the closings, right? Patty's Adam's paralegal. And Patty referred Sally to Adam. So what does he do? He gives her a referral bonus. And it is his practice to give her a referral bonus for every client that she refers to the office. Well, this implicates professional independence of a lawyer. And Adam violated the rules. This is a clear violation of the ethics rules to do this. Bonus payments to non-lawyer employees shall not be based on cases or clients brought in. Now, alternatives might be paying her a bonus related to something, for example, her extraordinary work. That's a fine bonus to do, but you cannot reward a non-lawyer employee for referrals. Preparing the closing documents. This implicates our responsibilities for our non-lawyer assistants, responsibilities of supervisory lawyers, and unlicensed practice of law. First thing we see here is Patty preparing the closing documents. In and of itself, that is totally fine. But keep in mind, the overarching rule is that a lawyer is responsible for the conduct of non-lawyer employees if that conduct would be a violation of the rules if done by the lawyer. So that's the overarching theme when we are looking at the conduct of non-lawyer employees, paralegals, assistants. If it would be a violation for us, it's a violation for them and it reflects on us. And therefore, we have violated the ethics rules. So Patty prepares the closing documents, not a problem, because it's the first draft and because Adam reviewed them and he marked them up. So clearly, he supervised her conduct. And one of the really problematic pieces of this question is the closing, which Adam chose not to attend. He went fishing instead. This implicates the responsibilities for non-lawyer assistants. Again, your supervisory responsibilities and UPL. Because when Patty, not Adam, attends the closing, it violates all of those because of the way it was done. So those that a non-lawyer employee may supervise a closing if, and these are really important. There are 5 factors and all of them must be true. And my advice on these is to know them for the test. And it will be in the outline. We'll forward an outline. It'll be in the outline that goes out to you. A non-lawyer employee may conduct a closing if the lawyer supervises and reviews all work done up to the closing. Here, Adam's good to go. He asked Patty to draft the documents and he reviewed them and he marked them up. Number 2, the supervising lawyer determines that attending the closing will be nothing more than a ministerial act. This means that the client has reviewed and understands the closing documents before closing. Here, Adam's conduct appears to have violated the rules. Why? The client doesn't appear to have reviewed the documents before closing, since there's a question about the closing statement that they raised at the closing table. Therefore, this is a closing that requires Adam's independent judgment. He can't just leave Patty there to answer the client's legal questions. Number 3, the client consents to a non-lawyer handling the closing. Adam's conduct here appears to violate the rules. The client, we've got the fact in there, the client's surprised he's not there. Where's Adam? Number 4, the supervising lawyer is readily available. Again, Adam messed up. He was out of the office fishing. He wasn't available when Patty called. Number 5, the lawyer will not give legal advice. So we don't know exactly what happened here, but I would throw a couple of things, at the wall in a case like this and say, if Patty attempted to answer the client's questions on the closing statement, it could constitute giving legal advice. That's unlicensed practice. And that reflects on Adam. Ultimately, her conduct is his responsibility. Additional rules to kind of just get out and put on the paper. A paralegal must work under the supervision of a lawyer or law firm. And a supervising lawyer must make reasonable efforts to ensure that a non-lawyer's conduct is compatible with the rules. For this one, here's your rules and your ethics opinions. Again, the rules and the comments to the rules and the opinions are right on point for this. And because there's some overlap here, there's not a lot. There's really not a lot to memorize. Just go back to what are your duties to the public? That implicates advertising, how you present yourself. What are your duties to your clients through all stages of the representation? And remember that it matters, but it's the client's view that matters. Pretty much everything has to do with their informed consent. And that's it. It's a pretty straightforward question to address. If y'all have any questions about it, if you think I missed anything, I would love to hear it. Okay.
Thank you for your poke, Cynthia, at the beginning. I think one of the things that I love in terms of when you look at the analysis on this is that the real estate broker and the attorney have different disclosure obligations. And if you actually chose to do both at the same time, you could have a prohibition on disclosure as an attorney and a requirement to disclose as a broker.
That's a great point. That is a really good point in this case, because the bad thing happening in the house, that's a mandatory disclosure for a broker, is it not?
There's a specific statute on it. I don't really do that much residential. I forget whether it's required or not, but it's one of but the point, I mean, I've seen it come up with other things, you have a non-disclosure obligation as a lawyer, but where you can have required as a realtor or vice versa. And it's one of those great things you think, oh.
Chat says it's not required to disclose. It's not considered a material defect of the property. But if somebody asks, you have to disclose it.
Yeah.
Is that true, Allison? Yes, that is true. Okay.
Yeah.
All right. So in this case, they aren't necessarily in conflict with each other. I too have I've never done residential real estate. So those rules are like way, way back when I took the bar. And maybe things have changed. I have no idea. Eunice, did you have a question?
Yeah, I just wanted to clarify at the beginning, make sure I understood this correctly. Although Sally contacted him as a realtor, he still has to fulfill all his ethical obligations as an attorney, even though he was acting in the role of a realtor?
It's a discussion point in this question, I think. Let me go back and look at she contacts him to sell her house. Adam, Beth, where is it?
It says that he takes her listing.
have him list her house. I think that's a great spot you just made. Is that in this case, maybe it's reasonable to assume because of that particular wording that he's a broker, not a lawyer. Should he still have, in my opinion, should he still have made that clear? Because the facts don't say that he did. Yeah, he should have.
Great,
If
thank you.
If you
Good
listen to
discussion point
Jason
though for
Ellis's
the essay.
materials on his presentation, he does a great job. He says, you know, you never stop being a lawyer. When you're in a bar, you're a lawyer. The ethics rule applies to you. It's just.
I love that. It's a great, his presentation is excellent, so. And a lot of what he presented would be very helpful for this particular question. So that's my big piece of advice for the ethics section. Your knowledge doesn't have to be that deep on, you know, it's just what we can do with permission. Basically is what it all comes down to. And how not to confuse the public. Great, that is all for me.
Jennifer, we put this seminar together because we wanted to help. And we thought that everybody lives in their silo and doesn't know everybody else that's going through the same thing. And we thought one of the great benefits of doing this and participating is you get to see which of your peers you know. You get to see, as Jennifer talked about, study buddies. So what we're encouraging everybody to do now, I mean, we'll stay here to answer questions, but we're encouraging everybody to take off your mute, put your video up and talk to each other. Because we think, you know, these are the peers that are going down the path you're going down, and having them magically available to you is an opportunity that we thought that was part of the benefit of this seminar. So we encourage you to do it. We'll stay here to answer any questions. Anybody, when everybody is done, they can sign off. I'm sorry, one other thing. We do this to give back. There's no, and what we really ask of you is to email us and tell us what we can do better, or stay on and just tell us, you know, you should have gotten the materials earlier. You should have covered this, covered multiple choice. Tell us, because this is only the second year we're doing this. Last year we had 6 people. This year we have 23 people. So we want it to be better, and you're the ones that can tell us how to make it better. So we greatly, greatly appreciate you doing that. And thank you all, to Jennifer, to Stephanie and Caleb, for Cynthia, for just doing the effort to do this. So we thank you all for that too. Does anybody want to talk, or we can, you know, we'll hang around, but anybody, the formal portion of the session is over.
Hi, I did have a question on the 6 essays. As far as the topics go, we covered ethics. I would imagine the ethics is a short answer portion. Is there any gauge as to the remaining 5, or is that just a
You know, until Jennifer, do you want to answer that, or you want me to? The historically, for the last 8 or 9 years, they have put on the website what the 6 short essay questions were. And this year they removed that from the thing. And they specifically said, okay, one is landlord tenant, one is buyer seller broker. And they told you. And I called the chair of the committee that's writing the test and said, Rebecca, why'd you do that? And what she told me was that BLSE told them that they're not allowed to continue to have the same 6 topics every year, and they're going to rotate them. So they took it off so that they can make those decisions. But I would think that it's not, they're not gonna, it's a governmental entity. Nobody is that agile. So it's highly likely that what they have done historically, they will do again. But we don't know what they're going to be. But we can tell you that historically, they were landlord, tenant, seller, buyer, broker, ethics. Let me see if I can come up with a list of what the rest of them were. Let me see.
I think one topic was real estate litigation.
Yeah, I mean, again, I don't remember.
Oh, you know what? I think it's in that study guide. I think I might have. Oh, they updated it, the one from last year. I remember now what you're talking about. I have full, but I can't remember off the top of my head.
Right. So it was in there every year. And when I went to prep for this seminar and it wasn't there, I called and said, what'd you do? Why did you change this? And she told me, they said, we were told we had to. So let me go look at the 2024 materials. Rebecca, here it is. So historically they were litigation, title issues, lien priorities, seller, buyer, broker, real estate financing, and landlord tenant. But there's no guarantee that those what they're going to be this year. I'm sorry, Stephanie, what?
Did you say that, Liz?
Sure. Historically, the 6 essays were ethics, real property litigation, title issues, lien priorities, seller, buyer, broker, real estate financing, and landlord tenant.
I've got a question regarding essentially the examination specifications, and it states that you'll be tested on the law, both statutory and case law. Are they looking at citation case law and like the actual, if it's chapter 83 for landlord tenant, or is it more of the concept based around the laws that we practice and the cases that kind of interpret such?
Nobody expects you to cite cases with authority. You have to demonstrate to know. You can say Johnson v. Davis.
Right.
And you can say chapter 83, but nobody's expecting because everybody knows in practice you go look it up, right? So nobody that's grading an exam expects you to be citing stuff with that level of specificity. If you do, it just proves you have knowledge, but it's not a requirement.
I think I cited no cases, none, not one. And very little statute, like maybe a 718 or something. But
I
yeah,
agree
you can
with
definitely.
Cynthia on that, guys. I don't know that I would like sit down. Like Manny Farach did an amazing presentation the year I did the board cert review. And I don't know that I would go memorizing Manny's case law review. I don't know that I would memorize it.
Perfect.
I agree with all of that as well.
Thank you.
And again, they tell you in the exam specs, there's not, they write the exam in October and November, put it in a can in January, February. So there is no, they don't want to do anything. And they tell you they're not going to look at anything after December 31st. But the reality of it is they want to write clear questions, because the hardest thing to do when you're in the grading room is to have 2 right answers. That actually happens on multiple choice questions sometimes, but I mean, so they want to give people things that test people's knowledge, but they don't want to have, they're not trying to trick anybody. They're trying to make questions that test knowledge.
I've got a question. What are the pros and cons of taking the exam in person versus doing it on your own? I know that there's a way to do it either way. Do you have any advice? What's the breakdown of people that do it without going to the Tampa location versus doing it on their own?
The recent test takers can talk about that. I don't have any.
I would do it on my own.
I did it on my own too, at home.
I would do it at the house. I would get everybody out of the house that you can get out of the house, and shut your door if you can, and lock in. Because again, you're going to start, the adrenaline flows, you kind of black out, and you just take the test. You know what I mean? So ideally, you kind of got to get. I want to do it at the house because I'm most comfortable in my office, right? That's one less variable that like I'm unfamiliar with. So for me, I prefer being at the house. So that's just my 2 cents on that one.
I did it on the computer as well, and I really liked that for a couple of reasons. But my understanding is if you do it in person, you have to write instead of type, and you don't have the same format.
Yeah, so I've taken it twice and haven't passed. That's why I'm here again. And I write because I am just superstitious, like beyond like in epic proportions. And it's been a couple of years since I wrote, but when you write, I mean, it's like bar exam all over again. Rickety tables, you know, you got a monitor, you got like the blue books, and your hand, you can't feel your hand at the end of the day. So basically, you know, I do a lot of outline and rewriting as I study for it. And I just start practicing my writing. But everybody that I talk to that takes it, they just, you know, the computer's great because you can do the outline. My blue books by the end look awful, but I just keep missing it by like 6 points, unfortunately. So I'm just back at it.
Well, we wish you luck for this year.
You'll pass it. You're gonna pass it this time. We're gonna put that in the. We're gonna put that in the ether. You're passing this round.
I appreciate it, Caleb. I mean, it's, you know, having children run a business and trying to study this. It's really, it is tough. But I would also say, don't give up. Like when you do this, there is, if for some reason you can't get it done, they do the summary application the next time, and you can go to the exam review. I think it was at the airport last time I did it, and that's really helpful too to see like what's going on. I had bad test anxiety the first time. I totally pooped the bed on the transaction question, and I literally wrote nothing about anything but land trust because I had memorized the statute. And the next time I took it, they literally said at the top, "Don't talk about land trust." It was that. So don't worry. You guys are going to do great. Everything happens when it's supposed to happen.
Weren't there requirements to do it remotely to have somebody like stand there and like certify that you didn't use any external resources or anything like that? I recall seeing something along those lines in one of the documents. I can't find it now where the requirements are, but I recall seeing something along those lines.
When you take it at home?
Yeah.
I don't remember how that worked. Caleb, do you remember?
Yeah, they monitor you. So but I mean, even if you had open book,
you're being recorded.
You don't have time, man. I mean, just being on, you know, even if you were sitting there, like if I had a plethora of resources next to me, you wouldn't have time to flip through them anyway. I mean, the thing's set up that you got to kind of know it, you know? So, but yeah, they're monitoring you if you take it at the house. ExamSoft, they've got somebody watching you.
Yeah. And make sure that you follow the instructions, like do it right away. You're going to get emails that tell you if you've not used ExamSoft before. I hadn't before this because I used to be a handwriter blue book person. But I actually really loved it. But yeah, you have to make sure everything's working properly. I would highly recommend doing that as soon as you get those prompts.
Yeah, and also I would add when you do that, they give you an option not just to set it up, but to actually do like a practice test.
Mhm.
A lot of people skip over that.
Oh, yeah,
step.
yeah.
But in the practice, it's not a practice test that has anything to do with this test, but you can see in there how you can go like, while you're in the morning session, you can access everything that's within that session. So for me, I'm very, I don't know, black or white when it comes to multiple choice. Like I either know it or I don't. Maybe there was a couple, but you can actually flag them in the online system. So I learned how to do that so that that day I wasn't so worried about it. And then I was done with the multiple choice a little faster than I needed to be, which then gave me time. And if there's questions that you feel like you're strong on, especially in your essays, you know, write those out. If there's others that you're like, I have no idea, do a little bit of something and then go to another one. There was literally one of the short essays that I literally wrote. I do not practice in this area. I have absolutely no idea. These are probably issues. I would definitely have to seek somebody else that knew what they were talking about or do significant research. And I moved on to the next question. Like I kind of caught maybe a couple of points if I could, and I went on and did other ones. And then when I got to the end, I had a few minutes left. I went back to it, read it again. Maybe one or two other things clicked and I could add it in, but I definitely recommend doing it electronically, not writing. And I thought it was really great to be able to switch between questions and have the tools to flag where you want to go back to.
Yeah.
Yeah,
It
the
was- that's a
technical,
great
the
point.
tech
You can
rehearsal.
practice.
Yeah, ExamSoft has a tech rehearsal, as she was alluding to. You can do that a couple of days before the test and make sure your computer's not gonna fail to like upload the answer or something like that, right? So the system runs to a full test. And ExamSoft, I used ExamSoft in law school, so ExamSoft is a reliable software, by the way, but it will let you test run it, and send a test response packet, and it'll make sure your computer is not malfunctioning with the communication with the server and all that stuff.
Yeah. Anything you can do to take other anxiety of the X factors away from the test is a really good idea.
Can I ask you again about when you structure your essay questions? As an example, can you basically outline versus writing a dissertation with paragraphs? So if there's 3 call questions, can you set up a bullet point 1, bullet point 2, bullet point 3 with each call, and then basically outline under it? Or do you have to really?
Yes.
I mean,
That's what I did,
yes.
David.
Okay.
Because
So I outlined it, and I just you're trying to just gather points, right? So to use a metaphor, stick and move, right? You do your outline, hit your points, put a blurb, go. You know what I mean? Because there's just a lot of points to be had, and you got to keep it moving. You know what I mean? I felt like
It's
that
not
was
your-
the challenge of the test. It was keeping it.
It's not
moving,
your quality writing they're looking at, right? It's issue spotting and throwing it down on the page and moving on to the next, right? Okay.
Yes.
And especially once you get to those short answers at the very end of the day when you are exhausted and you are putting your all out on that paper. Yeah, use those outlines. Get out what you know fast.
Also, just a tip. This is a personal mistake that I made the day of the test. Eat something before you drink like a bunch of coffee, because I walked into that test way too caffeinated. So I'm just saying, guys, I was way over caffeinated. Now, if it was fine, it worked out, but I would recommend just eat whatever your routine is in the morning, like with a bar exam, right? Just don't mess with your routine, whatever that is.
How did you guys prioritize topics as far as studying? Did you focus on, I would imagine, the ones you knew the least or least practiced and really honed in on those?
Yeah, that's
I'll be
exactly what I
honest.
did.
Okay.
But homestead, obviously, homestead is number one. There's homesteads, you're gonna see it all over the place. And then like for me, foreclosure. I'm not good with foreclosure. So yeah, I looked at that. I know, I'm sorry, Caleb. It's terrible, but I'm not.
I would also say the topics that have very specific things. Like I remember being peppered throughout a lot of landlord tenant questions in the multiple choice and in some short answers that you really had to know when the, what type of lease it was going to be, and then how many days of notice you would have to give them to get out. I remember seeing the notice of commencement dates a lot. So any area of the law that you don't practice in regularly, that you may need to actually memorize those numbers, those are the kind of things that you can even flashcard getting ready. But definitely where they can find the most practical, concrete points, I felt like they hit those. So I thought that was important. And definitely the areas that you're weak in. But even if it's something that you don't do a lot of and you're like, oh, I always have to look up these dates or this number of days or whatever the period might be, there was a lot of that.
Yeah, and I'll tell you guys, like the guy who did the presentation at the board cert on foreclosure, ridiculously detailed, great. I'm sure he's like the best. He's got to be one of the best foreclosure lawyers in the state. The thing was like 120 pages. I abandoned foreclosures because I got to reading it and I was like, eh. I read the title notes on foreclosures. I stuck to I was worried about landlord tenant because I never practiced that stuff. Bankruptcy, I went to the title notes for bankruptcy too. I didn't bankruptcy, I get that in certain cases the judge is second to God. And other than that, I just kind of stuck to the title notes. And yeah, I mean, you got limited time to study this stuff, especially, everybody's practicing. A lot of people have kids. You only got a couple of hours at night when the kids go down to get this stuff read and get it done. So you kind of gotta pick your poison, So yeah, I mean, I would prioritize the things you don't practice. Like, I think it was David. David, I don't think I'd look at doc stamps, my man. Like, I think I would just, I think I would just, you got doc stamps, just go do something else, Anyway.
I actually think there is a section in the Brute does a good like sort of I think they're good for multiple choice, the sort of examples that he has in that short outline. When I study, I hone in on some of that because I think it's good for multiple choice.
I have a question. Can you think of any resources for maybe like commercial landlord tenant? What might be good to look at for that? Because that's one area that I don't practice in, that I would wonder where I could get a good result.
Well, number one, the statute, number one. Commercial landlord tenant. I'm trying to.
Didn't Brenda Azel's presentation from the review course have a commercial section?
It does.
If you look not only at Brenda's, which is a much more blended, but it also in 2024, Jennifer Tobin did it and she had a different set of materials. If they make those available to you, that's a very good set of materials also.
Thank you.
Anybody else want to talk about anything else?
Are there any subjects you think are really not worth paying, like going too nuts over, if it's something very remote that you didn't see? Or do you think that when they have their list of everything, it's really and truly like all of this is obviously like homestead and transactions, but for everything else, is it all kind of distributed well? Or if you happen to remember, or is it like landlord tenant heavy, for example?
I don't remember a foreclosure question. I mean, that's just my year was 2023.
Yeah, they're all different because I do.
Yeah, they're all different. Yeah.
Right, but if you have a multiple choice question and you're not ready for it, it's only 3 points, right? So if they do something that's really narrow, then you have a 1 out of 4 or 1 out of 5 chance of getting it right. Just move on. But you don't have to go to the remote ends to cover yourself, because that's why we spend the time on the transaction analysis and the homestead and the ethics, because those are going to be there.
Yeah.
And they're just not one of the themes that y'all should be aware of is the goal is to help people pass. They want more board certified lawyers. They're not trying to trick people and to limit the pass rate. The goal is to have competent people pass.
But I will tell you, when you take that test, there's going to be some questions where you're like, ooh, that's man, that's in a remote corner of the, they hit me one with a
Yes.
flagpole and an HOA. They hit me one on flagpole and an HOA, and I was like, oh, ooh, so there's going to be those
Yeah.
moments on the test where you're like, well, I'm not getting that one, so
Okay.
let that go. I mean, just let that,
Right, because the short essays are all going to be kind of middle of the road because they have to be. So all the rest of the stuff is going to be multiple choice, right? Maybe there'll be some kind of off issue in a homestead as a piece, or transaction analysis as a piece, but it's not going to be the driving points. And multiple choice, there's a bunch of them.
I will say in the short essays, I was very surprised because I did focus on landlord tenant because I don't practice that at all. But at least 2 of them and maybe 3 of them specifically asked you to discuss damages from some sort of landlord tenant issue. And I practice real estate litigation, but most times that doesn't involve damages. Most times that's clearing title or getting somebody evicted. Very rarely are we actually talking about damages. The damages were a little bit obscure, but if you knew the basics of damages, which you wouldn't really, I don't know, I guess I didn't naturally pull that, but I was not prepared for the damages piece of real estate litigation or the damages piece of, one was, I think, the broker question. Actually, they had a real estate broker that was supposed to be renting their house out for them, and they failed to do something. So there was some aspect of that too. But I definitely was not ready for damages, and I just had to skip over it, which obviously it worked out. But I thought that that was something. I did spend also a good bit of time on bankruptcy, and I did feel like when I left, there was not many bankruptcy questions. I don't know if Caleb remembers any bankruptcy questions, but I'm not sure there was any.
Not one. Mm-mm.
Are there any core resources to review other than, the Florida Bar review course? Like, what would your recommendation be?
I stuck to the review course and the title notes because that's all I had time. I got a wife and 2 kids. Like, that's all I had time to do.
The
I
title
think-
standards can be
Yeah, I
really
didn't have a chance to
helpful.
do the title standards, but the title standards are,
Yeah.
I'm sure, because they have examples in the title standards, like especially
They do.
the MARTA stuff, they have examples.
Mm-hmm.
So I'm sure that stuff would be very helpful. I ran out of time personally.
What
I
did
went out.
for- Go
I'm
ahead,
sorry.
Cynthia.
Oh, sorry, Stephanie. I went out and found somebody's really cool timeline of construction lien law. And then checked it, to make sure everything was right against the statute and what I know about it. And so I created like a nice little timeline there for that. For the things where the materials from the review course were voluminous, I read the statutes and then made a couple notes. But yeah, if you have access to the title notes, those are really helpful, especially on MARTA and homestead.
It was my
the statutes for
resource for
landlord tenant
foreclosures.
are important.
Okay,
Foreclosure, I
yeah.
just read the statute for foreclosure. Yeah.
I would say I wanted more multiple choice, and somebody gave me the really good idea. If you're a member of the fund, not that I'm trying to plug any one underwriter, but their little title teasers questions that they have, when I didn't have a lot of time, my assistant had actually gone through past issues and pulled those for me, and it was just a really quick, easy blurb of something to read when you were waiting for an appointment to start or something. Like, I literally read probably 2 years worth of those over 4 months. And it was just like really good little tidbits that I did feel like came up in some of the multiple choice questions.
Stephanie, I'm so glad to hear you say that because I'm the editor of the title teasers, as a matter of fact. So
I
glad
knew
to
you
hear
were
you say
gonna
that.
have to
You're
chirp.
doing a great job, Caleb.
No wonder you passed, Caleb.
I inherited that from John Benson. If y'all know John, he's an underwriting manager with our operation. But so glad you liked him, Stephanie.
Yes, love title teasers.
Well, again, please send us an email. Tell us what we can do better. Tell us what you liked, because we're going to do it again next year, and we're babies in learning this process. So let us know.
Thank you so much for your time, for helping us.
you.
It's been very good, very
Good
informative.
luck, everybody.
Yeah, we look forward to welcoming as many of you as possible into the group. And the way it works is we'll be looking for 2 people that pass to be part of this it's a 2-year commitment. We'll be looking for 2 new people next year to come lead the seminar. We're hoping some of them will be you. Have a great day.
Bye, everybody.
Bye-bye.
Bye. Thanks, everyone.